For judgment item number 1, JCRLA 74 of 2011.
In the result, the conviction of Puramani and sentence imposed on him is confirmed. The appeal preferred by him, that is JC.
Mr. Rautri, you're not audible. 1 minute.
Audible?
Yes, now you're okay.
Sir.
Ah.
In the result, the conviction of Puramani and sentence imposed on him is confirmed. The appeal preferred by him, that is JCRLA number 74 of 2011, is dismissed. In respect of Sukanti Behera, she is acquitted from the charges. The appeal preferred by her, that is CRLA 30 of 2012, is allowed and the bail bonds are discharged.
I agree. Right. They have not served means who?
They have not served my copy.
Who is they, sir? I think.
My lord.
Who has filed the counter affidavit that the copy has not been served upon you? Who is the party, opposite party?
Opposite party is state, my lord.
State.
So who is representing the state?
State is represented by Mr. Samantarai, my lord.
So we let him be here, sir.
I may be permitted to place the order, my lord.
Sir, you can wait.
Yeah.
Yeah, it will get called out, sir. It will get called out.
Oblige.
Weekly list, old matter, item number 1.
May I please, Your Lordship? Now, this is a matter which is pending since 2001, and in the meantime, since the petitioner expired, my lord, a substitution petition has been filed by the wife and the.
We'll allow it. Tell us what the matter is about.
Yes, my lord, the matter relates to the challenging the.
Substitution is allowed.
My lord. My lord, this matter relates to challenging the order of the London Tribunal, my lord. Initially, the petitioner had approached before the London Tribunal.
Is the issue alive, sir? This is going on deputation, giving relief by the parent department. What is the age of the person now?
Expired, my lord.
Then what are you pursuing?
My lord, it relates to non-payment of the salary for a period of covering a period of about 84 to 90 months, my lord.
What months?
84 to 90 months.
Months.
Yes, my lord.
So why was the salary withheld?
Because, my lord, there is a correspondence to that effect that the order of the transfer or deputation or reversion that has been set aside by the London Tribunal. Now the issue is that whether the consequential order, that is relief order.
No. Did you go and join, or you stayed wherever you were? If you went on leave, you didn't join, then how will you get salary? No
But
work, no pay, sir.
My lord, the case is that, my lord, there are correspondences where the OCC has admitted, Managing Director OCC has admitted opposite, but no for admitted the fact that there are documents to show that this petitioner was continuing under them. Now, if they are saying that they are continuing,
Did you work or not is the question, sir. Give us your list of dates you have.
I have already supplied. My
All right.
This is a transport people. My file shows, my lord, that a date chart has already been.
All right. So we are deemed to know the matter. Good. Both of us are deemed to know the matter.
No, my lord.
Ah.
Absolutely not, my lord. I am supposed to place the facts, my lord.
Yeah.
My lord, the only thing is that, my lord, may I take your lordship to
Everything, all permissions granted, sir. Please argue the matter now. Yes. Kindly argue. Tell us the facts.
My lord, there is an order of reversion was issued, my lord, while the petitioner was
On a certain date or no date?
Yes, ma'am.
Undated order, he was reverted. No. Sir, you have to give us the dates chronologically. What happened when?
Yes, ma'am. My lord, it is 28/6/1996, my lord. While continuing under the deputation under the Managing Director of OCC Limited, the petitioner was reverted. And by way of reversion, his services are placed under the disposal of the DRD, another foreign agency. So since from one foreign agency to another foreign agency, a government employee cannot be transferred. In view of the restrictions imposed by the Finance Department, he approached before the London Tribunal, challenging the said order, my lord. That is on 24/7/1996, my lord. And that original application bearing number 1787 of 1996, that was disposed of by remitting the matter to the authority for consideration of his case. That is on 24/7/1996, 26/7/1996. Then on 7/8/1996, they rejected and they confirmed the order of reposting the petitioner to DRDA, Sonpur. So that order of 7/8/1996, as well as rejection order, as well as the order dated 28/6/1996, the original order of reversion. Those two matters were challenged before the London Tribunal by OA number 2093 of 1996, which was disposed of on 16/8, it was filed on 16/8/1996, and that has been disposed of by Annexure 1 to the present OJC matter.
After 2.5 years.
Pardon, madam?
After 2.5 years, the OA was disposed.
Yes, ma'am.
Yes.
And all the orders were set aside, quashed, ma'am. The order of reversion, the order of rejection, all the orders were quashed. But admittedly, there is an observation of the London Tribunal while disposing the same, which is at page number 22 in my writ petition, present writ petition. May I read that some small parameter? For the reasons indicated above, the original application is allowed with a direction to the state respondent to bring back the applicant to the parent department within 15 days from the date of receipt of a copy of this order. I would direct the applicant to apply for leave for regularization of his service for the intervening period between the date of relief from the OCSC Limited and the date of joining at Sonpur. Admittedly, madam, this particular operating portion of the order with respect to submission of the leave application, that has not been challenged by the petitioner while he was in service. But when this order was also not implemented, even after the order, then he filed a contempt petition, but during that period, it was mispetition. And the order of the mispetition, which was by the London Tribunal, is on 24/11/1999, is at Annexure 2, page number 23. And there it says that London Council, appearing for the petitioner, repeatedly submitted the service of the applicant had not yet been withdrawn from OCC. It transferred from the papers enclosed to the annexure to the show cause that he is working in the OCC under the premises with a view to ensuring implementation within 10 days from the date of receipt of the copy of this order. That was the order passed by the London Tribunal on 24/11/1999. Pursuant to that order, the Annexure 3 order, that is on 4/12/1999, the order was passed, madam, wherein the reversion order, my lord, previously what it is issued, that was withdrawn, and the order was complied. Now, relating to that intervening period, the salary for the intervening period, when the petitioner submitted a joining report, the authorities are saying that since you have already been relieved in compliance to the previous order of reversion, that is why we are not supposed to reissue any relief order. That is the point which was agitated before the London Tribunal once again. And by Annexure 10, it was decided at page number 44 on 28/9/2021, rejecting the prayer of the petitioner. This is petitioner. That this particular period cannot be treated as duty and he cannot be paid with salary because he has to submit the application for leave for regularizing that particular period in view of the previous decision of the London Tribunal. And admittedly, that has not been challenged by the petitioner in the previous occasion. The entire issue now, which is now before your lordship, we need to decide that much.
Again to the tribunal, sir. One important step you have not narrated. You again went to the tribunal.
Yes.
So please read that order, Annexure 10.
Annexure 10, that is the order, my lord, which is I have impugned in this.
Thank you, sir, for letting me know that. Please come to that order.
Yes, ma'am. It is at page number
please
44.
Come to page 46.
It is page number 44.
46 is the operative portions.
Yes.
Regarding the second prayer.
Yes. Regarding the second prayer, a direction to the MD to revert him is also not necessary since he already stood relieved by the time when he filed the earlier OA. As is clear from Annexure 1, the London Council for the applicant submits that the director has mentioned in Annexure 2 reversion from OCC, a further order from the OCC reverting him that organization is necessary. This is totally misconceived. A distinction must be made between
He
reversion
doesn't
and
want to
relief.
leave OCC. He doesn't want to come back to the parent department, and he says, now pay me the salary.
I have gone through that order, my lord, and this is the uh, dispute which is now pending before this honorable court in this case.
Your Lordship, may kindly on to page 44,
Yes.
tuned order. The applicant was an employee under the Director of Economics and Statistics who was on deputation to the OCC. On reversion from the OCC, he was posted to the DRDA Sonpur, which is challenged in OA number 2093 of 96 on the ground that after one spell of deputation, a government servant should be brought back to his parent cadre and cannot be sent on deputation to another foreign employer. That OA was disposed of on 18/1/1999.
No, that's all facts, sir. He's just told us all those facts.
No interim order was passed.
Ah.
He never joined. Well, your Lordship, now your Lordship may kind on to have filed
So
further.
without joining, he wants salary for that period. Without joining,
Yes.
he wants salary for that period.
No work, no pay. That is the principle.
Or the
And
challenge
also-
in the present petition is an order dated 28 September 2001, passed by the Orissa Administrative Tribunal, disposing of the petitioner's OA number 2183 of 2000 and declining his prayer that between the period of his being relieved by his borrowing department, that is the Orissa Cement Corporation Limited, bracket OCC, and rejoining his parent department, that is the, which is the parent department, Water Resources,
No, no.
No, Director of Economics and Statistics. ma'am.
Director of Economics and Statistics, bracket opposite party number 2, he should be paid the salary. Incidentally, this is a petition filed in 2001. Full stop. The petition is stated to have expired. Full stop. Now he is represented by his LRs. Full stop. Paragraph. The petition before the OAT was almost the third round of litigation concerning the petitioner's deputation to the OCC. Full stop. Aggrieved by his being sent further on deputation from OCC to the DRDA, District Rural Development Agency. The petitioner had approached the OET, which by an order dated (18/199) allowed the petition and directed that the petitioner be reverted to his parent cadre. Full stop. Incident. In the order dated 18/1/1999 by the OAT that the government will post the petitioner in any suitable post in the parent department within 10 days. Full stop. Aggrieved that that order was not complied with, the petitioner filed MP number 310 of 1999 in the OAT. Full stop. That application was disposed of by the OAT on 24/11/1999. Reiterating that he should be posted in any suitable post in the parent department within 10 days. Paragraph. Pursuant thereto, on 4/12/1999, an order was passed by the Directorate of Economic and Statistics, Orissa, placing the services of the petitioner and posting the petitioner at the headquarters of the DES with the effect from the date of his joining. Apparently, the petitioner did not immediately join. Full stop. He was insisting on a relieving order from the OCC. Full stop. That order came to be passed on 30th September 1991. Full stop. Aggrieved that not 91, it must be 2001. No? What
Sir.
was that order of the
May I say, ma'am? With the Lordship's permission, 91 Annexure 4 series, my lord, that is with respect to the identical persons who used to get
Oh, I
reversion
see.
type order, my
Okay,
lord.
where is your reversion order?
They have not. ma'am.
Acha. Apparently, the OCC did not pass any specific relieving order. Full stop. The petitioner ultimately joined back in his parent department. When did you join back, sir?
But I joined. That is only pursuant to in compliance of order dated 17/4/2003 passed in this
Yes,
matter.
ma'am. Yes, ma'am.
Joined back the parent department only pursuant to an order passed in this court, passed by this court in the present matter
17/4/2003.
on 17th April 2003. Full stop.
17th April, man.
That's what I said. 17th April 2003.
And he joined on 29/4/2000.
Joined on 29/4 pursuant to an order dated 17th April 2003 passed by this court.
Yes, ma'am.
Paragraph. In effect, therefore, despite being reverted on 4/12/1999 itself, for nearly over 3.5 years thereafter, the petitioner did not join back the parent department. Paragraph. The OIT has taken the view in the impugned order that there was no requirement for OCC to pass any relieving order, and therefore the demand of the petitioner that he should be paid salary for the differential period, that is from the period when he was reverted, where he was to be reverted pursuant to the order dated 24 November 1999 of the OIT, and the till date of his joining was not tenable in the IAS law. Paragraph. Having heard learned counsel for the parties, the court is of the view that the OIT has not committed any error whatsoever. So in the present case, there was no justification for the petitioner to insist that there must be a corresponding relieving order of the OCC, once an order was passed by the government, that is DES, on 4/12/1999, posting the petitioner to the headquarters. On the principle of no work, no pay, the plea of the petitioner that he should be paid salary for the period till he joined back in his parent cadre cannot be justified. Full stop. There are no merits in this present petition. It is dismissed as such.
We kill list item number 2.
But item number 2, 3, and 4, in all these STRB, the steps for limitation have not been taken.
All right. No steps have been taken for explaining the delay in filing the revision petitions. The petitions are accordingly dismissed.
We kill list item number 5.
Management item number 5, I am for the intervener. The first sub item.
All right. None appears to the petitioner. Dismissal, non-prosecution. All applications are disposed.
Five.
That case is relating to service
Sir,
matter.
please speak into the mic, sir.
It is single bench matter, service matter, man.
It's all right, sir. Tell us what you are for the petitioner.
Mr. Senior Advocate Jagannath Patnaik will argue in this case, man.
So first,
Management, can you see the age of the petitioners? They all have retired,
oh,
including the opposite parties. Management, can you see the first title?
okay.
And in the first matter, my lordship, there's an interim order. The same has to be vacated. Because the interim order, my lordship, we are the beneficiaries who have been promoted from scale 1 to scale 2.
Right.
But because of the interim order, it has not been confirmed, your lordship. And in the meantime, they have also retired.
Oh, both parties have
Yes,
retired.
your lordship.
Yes, retired, but here in this case, seniority is claimed by the present petitioners. Dead chart have been filed My lord, senior advocate will argue in this case.
So it's a 2003 matter.
Pardon, my lord.
What? It's a 2003 matter.
2003 matter, my lord.
How many more years do you think it should be pending?
No.
For it to become eligible to be heard?
Time, the petitions have also been promoted.
It is a service matter.
No.
The petition have also appeared in the Department of Examination, and they have also been promoted to the same post.
Oh, I see.
Yes, the class 2, the scale 2 of the my lordship of the bank, in the Grameen Bank. They have also been promoted to the same post, my lordship.
Date chart have been filed, my lord.
All right. Tell us.
Pardon?
Tell us, sir.
Let it come next week, my lord. Senior advocate will.
So we'll impose 1 lakh cost. Is that all right with you? It's a 2003 matter, sir.
Monday only.
We can pass it over if you so feel like. You get ready with the matter and come back and argue.
Academic.
What? It will be decided on merit.
Since you're insisting on disposal and merits, we'll pass it over. All right.
Monday, my lord.
Sorry, sir. Sorry. All right. Pass over.
Weekly list item number 6.
My lords, item number 6 and 7 not pressed, my lords.
Not pressed, disposed of.
Obliged.
List item number 8.
None appears dismissal, no prosecution.
Weekly list item number 9.
None appears dismissal, no prosecution.
Weekly list item number 10.
May please, my lords. This matter is, my lord, of the same petitioner, identical to item number 32 of yesterday's supplementary list, my lord. That is STREV 21 of 2008.
Where we reserved orders.
So the same question of law arises for an earlier period.
All right.
1982-83.
Yeah, reserved, orders reserved. All right.
Maybe disposed of along with the STREV 21 of 2008.
Right.
Greatly obliged.
Disposed of along with 31 of 2008. All right.
21 minutes.
21.
21 of 2008. Item number 37 of yesterday's.
All right.
My lord, has kept that reserved for orders, that matter. So
that's right. This will also be reserved.
Reserved.
Weekly list item number 11.
Item number 11 not pressed, my lords.
Not pressed, disposed of.
Obliged.
Weekly list item number 12.
Well, my lord, the tax effect is 14,000 somehow.
In view of the insignificant tax amount, the question of law is left open. The petition is disposed of.
Weekly list item number 13.
My lord, beg pardon. I'm not having the records, my lord.
It's all right. Then counsel, the petitioner does not have the records of the case. The petition is disposed of for non-prosecution.
Weekly list item number 14.
14, my lord, tax effect is 11,000 somehow.
Yeah, in view of the insignificant tax amount.
Weekly list item number 15.
Item 15, I am appearing for the petitioner. In the writ petition, in the first writ petition, the award dated 18/5/2009 has been already under challenge. The first writ petition is filed by the management, and second writ petition filed by the workmen. My lord, kindly see, during the pendency of the present writ petition, my lord passed an order on 12/8/2010, order number 6. My lord, kindly see the order number 6.
Yes.
My lord, heard the Learned Counsel for the parties, both the writ petitions have been taken up, have been arising from one order. They are heard together, and the following common order is passed. The petition of both the writ petitions challenge the order dated so and so, passed by the Industrial Tribunal and indication of so and so. The reference made in the said case is this. Along with the 151 workmen, challenge the refusal of the employment by Oswal, Messrs. Indian Carbon Fertilizer Cooperative Limited. Is the petitioner, so and so, and the appointment of so and so. They are directed by the tribunal to reinstate only 8 workmen, that too without backwardness. So the workmen, through their union, has filed double petition of so and so for reinstatement of the remained workmen and for backwardness of 8 workmen who are directed to be reinstated. On the other hand, Messrs. IFCO challenges the said award on the ground that they are not liable to give employment to any of the workmen. Learned Counsel appealing for both Messrs. IFCO drew the attention of this court to the.
So this was remanded back.
But the issue was framed whether Messrs. IFCO
so it was remanded.
Yes, my lord. Remanded. Thereafter, it was heard by the Learned Tribunal and by the order dated 16 December 2010. he has already rendered his finding, and it is part of record, my lord. Part of record.
Yes.
Part of record. And once again he said, my lord, can I read the last paragraph of his order?
Yes.
After the remand order.
Yes, please.
In view of the paragraph 9, my lord, paragraph 9. In view of the discussions made above, it is held that all those disputed workmen whose retrenchment is found to be illegal are deemed to be the employees of the undertaking as on 39/2005. There is no dispute that all the employees who are on the rolls as on 39/2005 have been observed by the purchaser without intervention in their services. Therefore, the disputed workmen in whose favor the reference is answered are deemed to be entitled to be observed without interruption in service. That way, the first condition, clause A of the section 45F of the Act, is found satisfied. As regards the other two conditions, no discussion is required inasmuch as neither of the first party management has taken any plea that these conditions so far the observed employees are concerned were not satisfied. Therefore, this tribunal concludes that all the conditions in the proviso to section 25FF of the Act are satisfied, and the transferee has a liability to observe the disputant workmen whose retrenchment is found to be illegal. But in the original award, at page 39, the presiding officer industrial tribunal has directed that 8 of the workmen are to be.
Anyway, this time around, everybody has been asked to be taken back.
Yes, my lord. In this scenario, I think nothing much left to be decided in both the writ petitions.
All right.
And both the writ petitions may be disposed of accordingly because of the second order, the remand order.
All right.
Hello, in this case, my lord, I am for the workman, my lord.
Yes, sir. Tell us.
My lord, in this case, my lord, I am for the workman, and our has been passed since 2010, my lord. And since 2010 till today, all the workmen are not reinstated as per the award passed by the industrial tribunal, my lord. My lord, senior submitted that 8%, but thereafter, after remand of this order by this honorable court to the industrial tribunal answer this award, and all the 151 workmen should be engaged, reinstated in this service, my lord. But till today, they have not complied the order of the industrial tribunal.
For non-compliance of an award, you know what provisions to invoke, right? You see, on 12th August 2010, the following order was passed by this court in both these writ petitions, one of which is by the management, being WP Civil number 9842 of 2009, and the other by the workmen, being WP Civil number 16443 of 2009, challenging the same impugned order award dated 18th May 2009, passed by the Industrial Tribunal Bhubaneswar in ID case number 4 of 2005. Paragraph. Pursuant to the above order, the tribunal again heard the parties and passed another award on 16th December 2010, the operative portion of which reads as under reproduce para 9, page 22 of annexure A5. Counsel for the Mr. Sarangi, learned counsel appearing for the management, submits that in view of the above development, nothing survives as far as the main writ petitions are concerned, and they may be accordingly disposed of. Paragraph. Counsel for the workman makes a grievance that despite the subsequent award dated 16/12/2010, the workmen have not yet been reinstated in service. It will be open, full stop, it will be open to the workmen to invoke appropriate remedies as may be available to them under the ID Act for that purpose. Paragraph. With the above observations, both petitions are disposed of.
Weekly list item number 16. Item 16.
None appeals dismissal not possible.
Just a second, my lord. My lord, what happened? My lord, in the second round litigation, the London Tribunal didn't allow us, our witness, to examine, my lord. The issues referred by the Honorable Court, my lord.
Which case are you appearing in, sir?
My lord.
Which case are you appearing in?
My lord, 15, my lord. Item 15, my lord.
So 15 is over, sir.
Somebody appeared for the workman here, somebody
am
appeared for
there.
the management.
I am sorry, my lord.
Why are you sorry?
My lord, the tribunal didn't allow us to examine.
Whom are you appearing for, sir?
My lord,
whom are you appearing for?
I am appearing for the union in the first case, my lord, opposite party, and second case for the petitioner.
Then who is the person who appeared here before us just now?
They are the interveners, my lord. I don't know who are they.
I am the workman. I am the workman in 984 first case. With the intervenor workmen who were not made a party in this case. I am the workman. I have filed the petition for intervention. This honorable court
You did not tell us that. You did not tell us that. So you waited for the entire order to be dictated for you to tell us you're appearing for workman.
My lord, just I wanted to interfere, my lord. I didn't want to obstruct, my lord.
What does that mean? I don't understand.
My lord,
now it's okay for you to obstruct.
My lord, the second round proceeding, my lord, the London tribunal, I am quoting the order, my lord. The second party files.
What is your submission, sir? Before you start quoting, what is your submission?
My lord, my submission is not the second round litigation. The tribunal categorically didn't that all 151 workmen shall be taken back, my lord. The confusion is there, my lord, that all these workmen whose services are terminated illegal like that, my lord. And the tribunal refused to take our witness. 51 workmen we produced before the tribunal rejected to take any additional evidence, my lord. May I place the order dated 24/9/2010 in the tribunal, my lord?
We are still not able to understand what your grievance is, sir.
My grievance is the second round reply, my lord. The London tribunal categorically didn't answer the reference made by this court, my lord.
Can I answer?
No, 100. So the confusion will go on. Management will take advantage of it. How they will implement, my lord.
What is the confusion, sir? All of you are getting back. All of you are being reinstated. What is the confusion?
Your lordship may say that all the 150 workmen already out
That's
of
what the tribunal says.
18 workmen already they have observed, my lord. And first round litigation, 8 workmen were directed to be reinstated. They were not reinstated. They are not paid 17B. My miscase is also pending there, my lord.
Yes, Mr. Sarangi.
And now the tribunal answered the second round reference that whose termination is illegal, they are liable to be reinstated. What is this, my lord? The Honorable Court directed whether all these 150 workmen shall be taken back or not.
Kindly see. He is saying that we are not given to opportunity to adduce evidence. Kindly come to paragraph 3.
No. What is your answer? He says there's going to be confusion because the reference has not been answered.
Kindly see.
Your lordship may categorically say that all the 151 workmen shall be reinstated, my lord.
No. Not categorically. The issue was framed, and that issue has been answered.
My lord and friend, Mr. Sadang is confusing my lord.
My lord, how?
The court.
No. How can he confuse? No. I have never confused the court.
My lord, during pendency of the proceeding in the High Court, my lord and friend told that there will be amicable settlement. We ran behind the management for several times. They didn't settle the matter.
Please do something like that. I have never confused the court.
That is in the record. That is in the record. My lord and friend told that discussions are going on for mutual settlement. That is.
Mr. Sarangi, just come to the issue framed by this court in its order dated 12th August 2010.
Kindly come to the answering order. Answering order dated 16 December 2010.
Right.
My lord, on the top, whether IFCO is liable to give employment to all the workmen, 151 workmen, members of the political union, employment. But this is the issue framed by this honorable court, and it was remanded. Kindly come to paragraph 3. He is saying that we are not given opportunity. Kindly come to paragraph 3.
No, what according to you as the tribunal held?
Kindly come.
Yes, my lord. That is to be clarified.
Yes. I'm coming. Paragraph 9. In view the operating part, In view of the discussions made above, it is held that all those disputant workmen whose retrenchment is found to be illegal are deemed to be employees of the undertaking as on 39/2005. There is no dispute. But he has referred to disputant workmen while answering the issue, and who are the disputant workmen have been directed to be able to give him employment. Kindly come to the original award. Kindly come to original award. Original award starts from page 27. Yes, of the issue while answering now, time to come to paragraph page 37. Now coming to the question of relief, to which these workmen entitled to argued on behalf of the IFUGO that since it was purchased, the company under a sale agreement as per the terms and conditions thereof, it is no way liable to bear the extra burden. The management of Oswal be held responsible for any act or omission which occurred prior to taking over of the factory of IMISCO. Be that as it may, when the management of IFUGO has purchased the assets and liabilities of Messrs. Oswal and workmen and the workmen who are regular workmen of Mrs. Oswal, for no fault of theirs, they have suffered termination of their services. It is quite unreasonable to deny them employment under the management of IFCO is that retest concerns. The Mrs. Oswal is no more there to observe the workmen, which is also contrary to the provisions of the Industry Act. Hence, workmen, Sri Ajay Kumar Sahu, Niranjan Thatoi, Alek Kumar Das, Guru Charan Raut, Basanta Jena, Prafulla Kumar Barik, Himanshu Ranjan Mahanti, and Prafulla Biswal are held entitled to reestablish service under the management of IFCO on the same terms and conditions of employment of other workmen who are observed by the management of IFCO, since nothing that evidence of the workmen that after their termination from service, they have not been gainfully employed elsewhere, they are held not entitled to so. But why the London Tribunal directed this? He has only examined 8 workmen and the records of these workmen were exhibited. After considering this, he has directed this, that the 8 workmen will be reinstated. And he in the first order, the second order, he has said, the London Tribunal has said that the disputant workmen in whose favor the answer the award has been directed, they will be entitled for it.
That means, my lord,
but then the last line of that order of the award, para 9.
Para 9. My lord. Therefore, this tribunal concludes that all the conditions on the provision of the Act are satisfied, and the transferee has a liability to observe the disputant workmen whose retrenchment is found to be illegal. That means it is 8 persons. The retrenchment of these 8 persons have been found to be illegal. And they have been, and this reference order, second order, it has been directed that the liability to observe the disputant workmen whose retrenchment is found to be illegal. In the earlier order, the parent order, it has been found that the disputant 8 workmen, their retrenchment is illegal. And they have answered.
So the disputant workman is some expression that the tribunal itself has coined, correct?
Disputant workman in whose favor? Kindly see that all the conditions and so that's why liable to observe the disputant workman in whose favor retrenchment is found to be illegal. And the disputant workmen of 18 numbers, their retrenchment has been found to be illegal. Only 8. And
8 or 18?
No, 8. 8.
My lord, may I be
said 18.
My lord, may I submit a my lord, the first award, the 8 workmen has been named, but in the second award, no name has been referred. And my learned friend is telling that we are allowed for witness. I am placing the order.
What is the age of all these 151 people? What is their age, sir?
My lord, it will be around 45, 50 like that, my lord.
So we'll simply say around 45, 50. No need to specify anything.
My lord, that is the exactly.
Everybody else will take care of all that. Facts and all others will take care of.
No, my lord.
Only lawyers will argue, facts others will take care of.
My lord, I am placing the order number 56 passed by the tribunal.
So why don't you answer the
24/9/10.
question? You are representing 151 workmen, correct?
Yes, my lord.
How many of your workmen have crossed the age of superannuation?
Well, exactly 10 or 15 like that, my lord.
Sorry?
10 to 15, my lord.
Sir, you seem to have a wonderful memory, sir. I don't share that wonderful memory of yours. You seem to know exactly which 10, 15 people are 60 years plus.
My lord, if your lordship permits, I will calculate and place it before
We
my
don't have
lord.
to permit. We are asking you the question. You have to answer the question.
Not 10 to 15, not more than that. My lord.
How do you know?
My lord, there is
Sir, let us look at petition number 3.
my lord.
Do you have the paper book of 16443 of 2009?
Yes, yes, my lord.
Kindly do us a favor, sir.
Yes, my lord.
Come to petition number 3.
My lord.
How old is he? How old was he when he filed the petition?
51, my lord.
What will be his age today, sir?
51, 64, like 64.
What does that mean? He has crossed the age of superannuation?
My lord, after serving 4 to 5 years, they have
What
been
is petition number
terminated from
12?
service.
Petition number 12.
My lord,
Petition number 18.
I don't deny, my lord.
Petition
Some
number
of them have
19.
crossed 60, my lord. I don't deny, my lord. But they are not the majority.
Petition number 27. Petition number 31. 48. This is petition number 34. Tell us what is the evidence you placed on record, sir. Come.
My lord, I am placing order number 56 dated 24/9/2010 passed by the tribunal in the after remanded back to the tribunal, my lord.
Sure.
Here the tribunal said when we filed for evidence, my lord, second party, tribunal tells second.
Which page are you reading?
Again,
Which
my lord,
page are you reading, sir?
my lord, that is part of the LCR, my lord. LCR is, I think, not before, my lord.
Where are you reading from, sir?
My lord, I have copy of the certified copy, my lord.
Only you have it. We are not entitled to it, obviously.
My lord, that is.
We are not privileged to have your certified copy.
My lord, may I place it, read it, my lord?
Kindly do us that favor, sir. Kindly do us that favor.
Second party files a list of 51 witnesses to examine them for adducing additional evidence. On being asked as to the purpose of examination of those witnesses, the representative of the second party submits that since this tribunal, while passing the award in this reference which is challenged by them in a writ petition before the Honorable High Court, has allowed reinstatement only to 8 workmen, and therefore now the second party wants to examine all other workmen who are presently available to the union to exhibit some documents in support of their claim for reinstatement. It is submitted by him that now for non-marking of these documents or exhibits, this tribunal has not directed their reinstatement. Hence, it is pertinent to mention here that Honorable High Court have framed the additional issue and remanded the ID case back to the tribunal with a direction to give its findings and reasons therefore on the issue that has been so framed by the Honorable Court, with further direction that both the parties be given opportunity to adduce additional evidence. As per the direction of the Honorable Court, this tribunal is to return the ID case record to the Honorable Court with evidence, if any, adduced by the parties, and this tribunal findings on the issue within a period of 3 months from the date of receipt of the order. Honorable High Court order, High Court have not set aside the award. Not any specific direction is given to allow the parties to adduce additional evidence on all the issues. This tribunal is to answer the additional issue and resubmit the case record. This tribunal is not required to make a fresh award. So the parties are required to adduce evidence which should be confined to the additional issue only. The second party cannot be allowed to additional evidence, to adduce additional evidence on other issues. Now they cannot be permitted to remove the lacuna, if any, in the matter of adducing evidence on the issues which were dealt with by this tribunal in this award dated 18/5/2009, which has not yet been set aside, my lord. So, my lord, our witness were refused. We are not given natural justice, my lord, in spite of the direction of this honorable court. The honorable court, when directed, categorically stated that parties are with liberty to adduce evidence fresh, my lord.
Mr. Das.
My lord.
So if we, in 2022, if we remand this matter to the tribunal, you will be very happy.
My lord, if nothing is achievable now, let us take a risk of 3 months, my lord.
I see. All right. You are prepared to risk your entire workmen.
No, only 8 workmen reinstated. They may be paid the 17B wages, my lord.
For remaining workmen, it has to go back to the tribunal. You will start leading evidence now. You have a 5-year plan, clearly, Mr. Das, or 10-year plan.
Or your lordship may adequately give compensation, my lord.
Oh, we are not in a Lok Adalat, sir.
My lord.
You wanted to lead additional evidence. You want the tribunal to appreciate that additional evidence. We can't reduce it to a Lok Adalat, can we?
No, my lord. What now the position is clear, as my Laden friend suddenly told. Only they will consider the 8 persons.
Correct.
And out of 151, already they have allowed to work another 18 persons, my lord. So other workmen are also
Justice Patnaik and I are confused between 8, 18. We are traveling between 8 and 18 too often.
8 workmen who has been directed to be reinstated, they are moving outside. Out of 151 workmen, already 18 workmen have been already allowed to work there, my lord.
What is it, Mr. Sarangi? Now,
that is their witness stated before the tribunal.
Mr. Sarangi, is it 8, 18? What is it?
My lord, 8. All right.
8 is directed by the tribunal, my lord.
He says, apart from the 8 directed by the tribunal, you have allowed another 18 to work.
Yes, my lord. They have allowed, they have admitted in the tribunal, my lord.
My lord, with regard to his claim, my lord, kindly come to page 31 of the award passed by the London Tribunal. Page 31, middle part, madam. On the rolls as on 39/2005 from this. My lord got it?
No, 31 of your paper book.
Yes, madam, of the first petition, 984-2. 984-2.
This is the earlier award.
Earlier, kindly come to the middle part. From 39/2005, there is a date in the middle part. Who were on the rolls as on 39/2005? 1, 2, 3, 4, 5, 6, 7.
So it does say 18 are continuing.
No, with regard to the report, it is stated in the written statement that Messrs. IFCO, as per the information and records received from Oswal, out of 151 workmen alleged to have been refused employment, 18 workmen are continuing even others date. 22 of them has absconded and their whereabouts are not known. 3 of them were not on the rolls of Oswal, and there is a double entry in respect to workmen Khageshwara Samal at serial number 87 and 137. 6 workmen were working with the contractor, Mr. So and were not on the rolls of Mr. Oswal. And 101 workmen have submitted their resignation and voluntarily left the services of Oswal. Further, it is stated that out of the 101 workmen who have resigned from service, 59 have already received their dues towards full and final settlement. 37 persons whose accounts have been finalized did not turn up to receive them.
And the settlement not proved.
And the other 5 workmen, after submitting their resignation, did not turn up to settle their accounts with Mrs. Oswal. The allegation of the union that the management of Oswal have refused them employment is false. Malay, this is the situation.
No, this was your stand.
This is my stand
of the management.
What is the finding on this?
No, of course, my stand.
No finding.
Kind from the finding. Coming to my the issue number 2, It starts at page 33.
Yes.
As held by the Honorable Supreme, therefore, but they kindly leave it. Therefore, it is to be considered first as to whether the workmen have laid cogent evidence to substantiate their stand. They had all completed more than 240 days of continuous service under the management proceeding, the date of their so-called refusal of employment. In this connection, it is seen that the union has taken the stand of refusal of employment to the workmen in 3 pages. So and so and so, so and so, so and so. Though the union has alleged that all its
No, come to bottom of page 35. The finding is against you, sir.
Page?
Bottom of page 35.
35. My lord. The record does not reveal that at any point of time the workmen alleged to have been voluntarily left their jobs were noticed to resume their duties, nor the workmen alleged to have tendered their resignation and did not come thereafter were intimate to in writing to collect their dues owing to ascertain of their risk. The management of Oswal, as also the management of IFCO, have taken no steps to produce the so-called dangerous letters offered by the so-and-so. Exhibit A is filed on behalf of Mr. IFCO, showing therein the names of some workmen out of 159 names in the reference who are presently working with IFCO. In absence of any documentary proof, it can safely be said that on presumption only, the management struck off the names of the aforesaid workmen from its role, and consequently to cover up its lacuna, to forward with the plea of voluntary abandonment of job by some of their workmen and intentional avoidance if the full and final outstanding. In this context, it is appropriate to refer to the decision of the so-and-so, abandonment relinquishment, all the decisions he has discussed. Come to the next page, my lord. Come to the next page 37. There being a question of fact, onus lies in the management who took a so-and-so. On the face of the shortcomings indicated above, and in view of the observations of the Honorable Apex Court as also of our own Honorable High Court, the argument advanced on behalf of the management has no legs to stand. Accordingly, it is held that the workmen named above, all the above refused employment 384 so. Since the action of management amounts to termination of the services as well as provisions, it was the bound and duty of management to comply with the provision of section 25F of the Industrial Dispute Act so, which is admitted fact. Now coming to the question of relief, to which this workman entitled, it was argued on behalf of Mr. IFCO that since it has purchased the company under the sale agreement, as per the terms and conditions thereof, it is in no way liable to bear the extra burden. The management of Oswal will be held responsible for any act of omission. Be that as may, when the management of IFCO has purchased the assets and liabilities over a regular workman of Oswal, their leaver suffered termination of the service. It is quite reasonable to deny the employment under the management of IFCO. No more that to observe this which is also contrary to the provisions.
All these, the direction given is contrary to the findings. The finding is you have not placed any proof that all these workmen abandoned the service voluntarily. You made a claim that 101 workmen had left on their own, correct? That was your stand before the tribunal. 101 workmen had left voluntarily. But you did not place any documents to show that. And despite which, the tribunal is granting relief only to 8 workmen.
What happened? Because
so that is why it was remanded.
That is one way, because only because these only 8 workmen came forward to prove their documents. These 8 workmen came forward. None others came. No document filed for any other workmen.
Sir, when it was remanded, come back to the remand order. Were they not permitted to adduce evidence?
Yes. Come to page paragraph 3. Paragraph 3. Kindly come to paragraph 3 of the remand order.
Yes.
The parties were given opportunity to adduce evidence on this additional issue. Workman witness number 10 was examined by the second party. He adduced evidence.
Okay. No, but he says there was more evidence to adduce which was not permitted.
That is the only general secretary, only one person, my lord. The total list documents were refused. Categorically, the order has been passed by the London Tribunal that you not entertain the additional evidence.
And the honorable tribunal was directed to consider only this additional evidence, not the case afresh. And you wanted to adduce evidence to prove just to come over the lacuna you committed earlier.
that is the language you are telling.
No, that is not the
tribunal used. But
yes.
this honorable court categorically directed to take additional evidence from both the sides.
What is the evidence you have, Mr.
My lord, my service particulars, my lord, only the 8 worker were.
Where is that? You have enclosed it with your petition?
My lord, the 8
Where is that
workmen allowed
evidence?
only due.
Where is
My
the
lord,
evidence, sir?
The service particulars, my lord.
Oh.
Their token number, their get pass, their provident fund number, like all this, the service particulars.
Where is that, sir? Where is
Appointment
that?
letter.
Where is that? Where have you enclosed a copy of that, sir?
My lord, only the 8 workmen have exhibited in the tribunal, my lord. Others, they were not allowed.
Sir, you have it with you now. We can find out what was allowed and what was not allowed. Where is that additional evidence?
The 8 workmen, whatever documents they have exhibited in the tribunal.
Please, Mr. Das, don't talk in circles. We are not talking about 8 workmen. You are making a grievance that you had additional evidence to adduce and the tribunal did not allow you.
My lord.
Where is that additional evidence? We want to see what is that additional evidence.
That is, my lord, generally the service particulars.
Where is it, sir? Show us.
Annexure 1 to the WPC 16,443, my lord. Annexure 1, running page 21. Abstract of service particulars of the petitioners. Number 2 to petition number 51 under Oswald. My lord, the name of the workman, date of joining, employee code number, designation, provident fund account number, date of termination. This much abstract has been given with the.
But only you've given it only for 51.
Whatever available we had given, my lord.
No, sir. 151 comes down to 51 straight away.
My lord, at the time of filing, who are available, we have given them, my lord.
No. You can't be so casual, sir. Now, at this stage, in 2022, 18 years after termination, you want the tribunal to again examine evidence. You're not prepared to tell us where the evidence is.
This is the available.
This one chart of service particulars is not evidence, sir. You've simply typed out.
Provident fund account number is there, token number is there, and they have not contradicted, my lord.
Page 26 to 32, my lord. Page 26 to 32, there are all the lists are given by my senior. Names and designations, code number, date of joining, date of everything there.
No, again, it's only 50. No, how much is it? $54.
There is 3 lists, my lord. One list is for 50, second is there for 47, and third is for there.
No, but
54.
Is this simply a chart, handwritten chart showing these numbers?
Yes, my lord. There are 3 parts, my lord. First part is for 50, or second part is there for 47, and third part is there 54.
So if we send it back to the tribunal now, another 10 years gone. If that is what you want, we'll do it.
Your lordship may adequately compensate, my lord.
What is that adequately compensate? Unless you establish your claim, where is the question of compensation, sir?
The lordship may remind back 3 months.
The target. Lordship demanded it with the target. Lordship.
Remanded to the?
With the targeted time within 3 months, 4 months, your lordship.
We still are not clear. Suppose you stand in the box and simply produce this chart, will it amount to proof?
All the documents are with the company, my lord. All the.
For workmen, my lord, after going out of service, my lord, they are moving here and there.
Sir, we can keep aside Industrial Disputes Act. We can keep aside evidence, law of evidence. We'll simply say poor workmen, therefore petition allowed. Okay?
No, my lord. My lord, this is battle between two unequals, my lord. Your lordship may
So we'll
appreciate.
say battle between two unequals, workmen's petition is allowed. This is a good argument in law. When everything else fails, you argue this.
Your
When we
lordship
keep
are
asking you,
expert
where
of
is the
experts,
proof?
Your lordship may think.
We're finding all of this very casual, sir. See, what you're ultimately producing is just one chart. Mr. Sarangi,
My lord.
even you did not produce any evidence. You claimed some voluntary resignation, that you have paid off workmen, nothing, no proof, nothing, no documents produced, nothing produced.
My lord, Mr. Sarangi, if you can sincerely once, you can settle it here, my lord. Several times he assured me, but he is only telling for 8%, no, for no other persons.
My lord,
The worker who were at that time getting 2,000 in same work, now getting 25 to 30,000, my lord.
My lord, should I submit?
Yes.
My lord, I have submitted that some of them are, it is out of court to solve the issue. My lord, whatever I was stated, I stick to that. And I think some 50, around 40, 50 employees are with Mr. Das. And with regard to them, if at all some, without recording my concession, it will be directed 25,000, 30,000 like that, directed, they can get it.
My lord, 50 number, 60 number, my lord, I am alone, my lord. Mr. Sarangi has bulldozed the union, my lord.
My lord, they around 50% they are with Mr. Das.
I am alone, my lord.
No, you're not saying you have one Mr. intervener here. How many workmen are you representing?
My lord, all these came up, all these other came up.
21. So 51 plus 21, Mr. Das.
No, my lord, so some of them are with him also.
I see. They're trying, taking their chance. If one lawyer doesn't appear, the other will at least appear.
My lord.
Okay.
If it can be,
what we can do is like floor test. We'll ask all of them to be present in person before Mr. Sarangi. Then you decide.
I have faith on Mr. Sarangi, my lord. If you sincerely wants, he can do something. From the beginning, he assured me that we will have a settlement for all.
See, if you say, no, one thing we can do is we can send you to mediation if you want.
In that event,
my lord, expectation from both the sides is
Mr. Das, please allow me to submit for 1 second. My lord, this matter may taken up for 1 month or like that, and in the meantime, this person are not coming to us. So let them come.
No. So let them come forward individually.
Yes.
We'll give a timeline on that day. All these workmen who really have a claim will present themselves individually.
Yes. And will inspect the documents and whatever amount will offer, if they are agreeable. I'm without recording my concession.
All right.
My lord, nobody will individually allowed. My lord, nobody will be individually allowed to meet the officers, my lord. In the gate, they will be stopped.
All right, Mr. Das. Just listen to the order, please. Just listen to the order.
Give a letter to come and
Mr. Das, just listen to the order.
My lord.
The issue concerns, open quotation, the expression, single quotes, disputant workmen, full stop. Without categorically answering the issue framed for the tribunal to address by this court, namely whether the 151 workmen are entitled
whether IFCO is liable to give employment to all the 151 workmen, comma, the tribunal seems to have indirectly restricted the relief to only 8 of the workmen by calling them single quotes disputant workmen, unquote. Paragraph, it appears to the court that, no, full stop, Mr. Das appearing for 51 of such workmen, as well as Mr.
Niranjan Singh.
Mr. Niranjan Singh appearing for another 51, make a grievance that their clients were ready with additional evidence to be adduced as proof of their employment with Messrs. Oswald before it was taken over by IFCO, and no opportunity was given by the tribunal to them to place the evidence before it. Paragraph. With a view to obviating a further remand, which will interminably delay the matter, the court considers it appropriate to direct us under, colon, the workmen who wish to be reinstated in service and who have not crossed the age of superannuation, comma, will present themselves before the general manager who will
Yes, madam.
Sorry,
Yes, madam. Yes, madam.
general manager of IFCO at
Paradeep.
At Paradeep between 18th and 22nd April 2022 with all the relevant documents. The general manager will arrange to have these documents checked and verified. Full stop. It will be open to the IFCO to, if the documents are found to be in order, to either offer reinstatement or compensation in lieu of reinstatement. This is without prejudice to the rights and contentions of both the workmen as well as IFCO. It is expected that at least some of the issues that the workmen might get settled in the process. Paragraph. A copy of the outcome of such proceedings reduced to writing be placed before a report of the such proceedings be reduced to writing and be placed before the court on the next date. List on
Our 17B miscase may kindly be allowed, my lord.
After vacation.
List on 21st June.
Madam, obliged.
All right.
Our 17B miscase may kindly be allowed, my lord. For 8 workmen.
Let this happen and then we'll talk of 17.
Let you come.
Obliged.
Weekly list item number 16. Item 16.
None appears to.
Weekly list item number 17.
But not 2. This has become infructuous.
17.
7 in May, please. This is an award of 2010 million. Here, my lord, the crux of the point is, even though the issues has been framed and this has been answered in favor of the workmen, that whether the termination by the first party management is legal or justified, and it has been answered neither it is legal nor it is justified.
But you've given 25,000 as compensation.
Only 25,000 was.
But in which year, sir? 2010
it
was
is
a substantial
the
sum.
year 2010 million.
That was a substantial sum in 2010, sir.
My lord,
how many years of service have you put in?
I'm more than 13 years.
13 years.
13.
All right. Who's for the management?
My lord, we are appealing for the management lordship on behalf of Mr. Somnath Mishra lordship. He is on the accommodation of the 12th April. But
It's all right, sir. You can tell us.
Sorry, lordship, our file has been misplaced on our
right.
officers.
So, anyway, enhance the compensation.
Labor court passed the award, that is a
He's only asking
7,500.
for more compensation, sir. Nothing more.
My lord, once he has already received that amount of 25,000 lordship.
It's all right, sir. 25,000 is nothing.
Well, now the situation very poor condition is the management lordship.
What about him, sir? Just imagine what is the line of business for the management?
My lord, that is the jute industry, my lord. In
Jute.
Orissa, that is the biggest jute. Jakisan Das Mall jute products. These are Balison.
That's what. But he's already received 25, receive another 25. The short point involved in the present petition by the workman concerns the adequacy of the compensation amount of rupees 25,000 awarded to him in lieu of reinstatement by the Labour Court, Bhubaneswar, in ID case number 103 of 1991. Full stop. Despite finding the termination of his services to be illegal, the Labour Court has awarded, and despite the workman having worked for nearly 13 years, he has been awarded only rupees 25,000 as compensation. Paragraph Council, the management states that the workman has already received this compensation amount of 25,000 and that the financial condition of the management is not very good. Paragraph B, that is it may, considering that the workman had put in 13 years of service, the court is of the view that the compensation amount ought to have been rupees 50,000. It is ordered accordingly, and the Labour Court's award will stand modified accordingly. If, as claimed by the management, the sum of rupees 25,000 has already been paid, then the remaining 25,000 will be paid to the workman within 8 weeks from today. The petition is disposed of.
Condition now so owning is the management.
Sorry, sir, 25,000 is not a big amount.
But it's the second time, Your Lordship. That's the award of the past. Is the second time, Your Lordship.
Very
That's the
good, very
23rd
good.
something is enhanced, Your Lordship.
All right.
Weekly list item 18.
It's the same, similar.
17 and 18 of the same.
Same meaning what?
Two workmen, different workmen.
I see.
Management is
Same order in 18 also.
Weekly list item 19.
Recording my statement, Your Lordship. Recording my statement.
Yes.
All right.
Weekly list item 19.
I am appealing for the OSFC.
None appears to the petitioner dismissed in non-prosecution.
Weekly list item number 20.
I'm for the opposite party now.
Counsel, the petitioner is not present. Dismissed in non-prosecution.
Weekly list item 21.
Yes, ma'am. I am for petitioner. Industrial dispute matter. The only short question is that now the matter is taken up after being remanded by the Honorable Supreme Court. I am prepared a dead check. My placement. 4698. Letter by SN Corporation to government for closure. Government permitted for closure of the SN Corporation. A review petition filed by SN Corporation Employee Union to Government of Orissa. 17/11/98, government rejected the review petition. 21/11/98, notice circulated through ethics notice in notice board by SN Corporation for closure of the SN Corporation. 23/11/98, closure of SN Corporation and all the workers were terminated. 30/11/98, OGC 16610/98, filed by SN Corporation Employees Union before the Honorable High Court, Orissa, challenging the legality of the closure. 17/6/2003, COPET number 29/2003, filed by the before the Honorable High Court, Orissa, by SN Corporation. 7/1/2005, COPET number 29/2003 was disposed of with direction. There is therefore no necessity of passing orders of winding up the company at this stage. Accordingly, miscase number suspension is allowed and COPET number is dismissed. 22/6/2005, Messrs. SN Corporation wrote a letter to the Managing Director, Mrs. Sky Industries Private Limited, in para 3 of the sale letter. It is clearly mentioned about the rehabilitation package of ex-employees of Essential Corp as per their suitability and requirement while making the appointment in the plant. Answer 3. 24/6/2005, the authorized signatory of SCA Industries Limited wrote letter to Managing Director of SN Corporation. In the sale letter, there is an understanding that the ex-employee will be rehabilitated. Annex 4. 29/2005, the Managing Director of SN Corporation wrote letter to authorized representative of SCA Industries Private Limited, in which it clearly mentioned that to consider the case of the ex-employees and workers of Messrs. SN Corporation as per the suitability and requirement while making appointment in the plant as per the term and condition of the tender. Annex 5. 1/11/2006.
Sir, all your clients are now close to 60.
Well, only
Many of your clients, I think only 4 or 5 are in the 50s, late 50s.
Out of present petitioners.
Many of them have crossed 60, sir. Many. You want me to go through it? I can go with you. Come to cost title 5888 of 2011. Keep going down the line. 1 has crossed 60.
Yes.
2 has crossed 60.
Yes.
So what I'm trying to tell you is many of your clients, because of the pendency of these matters, many of your clients have crossed the age of superannuation.
Yes.
Yes. So what do you wish to do?
Because the illegality has been committed, for that way the compensation is to be given, my lord, because there is specific understanding that they will be rehabilitated.
See, one way is to send all of you back to the tribunal.
And another matter also we have raised, that they have not paid the retrenchment compensation on the date of retrenchment. It has been paid after 4 to 5 months. So it is that is the settled law, my lord. There is a question of is abuse of void, my lord. Therefore, they are liable to pay compensation. Further, without going to the merit motion, now the liberty was given to the petitioners to lodge the complaint before under the Industrial Dispute Act. The complaint was lodged and the conciliation fails. And after a failure of conciliation, the reference was also made. At that time, this Honorable Court, Supreme Court.
No, this Narvorum Power and Steel Private Limited, is it still there? Opposite party number 9.
My managing director, Narvorum Power Steel Private Limited, such and such. The grievance is Mr. Opposite party number 4.
What is now? Why have you implemented opposite party number 9? Can you tell us? You are appearing for it.
I am appearing for IDCOL, Your Lordship.
IDCOL. What is opposite party number 9 doing here?
Your Lordship, I've also no idea why opposite number 9 is there. But I can just give a brief account, Your Lordships, that actually SN Corporation was a private company.
Correct.
It was not a government company.
Right.
It was actually floated by somebody called UK Rath with the help of IPCOL. Later, we just purchased 43.3% of equity. We didn't purchase it. We actually gave them 22 crores of loan. So we became the major unsecured and as well as secured creditor. Your Lordships, they were referred to BIFR. They were declared sick. In 1998, Your Lordships, we make an application under 25O of the Industrial Dispute Act for closure to the government with notice to the workmen union.
So at that stage, this SCAW comes and takes it over.
Lordships, I didn't.
That SCAW Industries.
Your Lordship, SCAW Industries actually comes before the COPET.
Right.
What happens is BIFR says that this cannot be, you cannot rehabilitate them in any form. You just refer it to the concerned. They basically passed an observation for winding up and referred it to the concerned High Court. And in the concerned High Court, we all creditors as well appeared, and then the court said that do one thing: you float a newspaper, invite for selling of their assets, and see how much you get. So we did. 2 people came up. Some amount got collected. A major portion was paid to State Bank of India. Thereafter, Your Lordships, all the government dues, all the employment, all the dues to the employers, everything was paid off. And we had to write off all our, unsecured and secured loan. Government also gave a very big package of 246 lakhs for payment, which they themselves have bought on record. After all this got finished, And the closure order of 1998 was also challenged before this court. 2008, it gets dismissed. The union files gets dismissed. Thereafter, in 2006, they again file a writ application saying that we want to be rehabilitated under IDCOL. I mean, under me. I had no employer-employee relationship with them. Court dismissed that application. Then they went to the DLO saying that we deserve to get, these are workmen, we deserve to get employment. DLO rejects that matter in 2008. They don't come to the court. Again, make an application in 2010, self-same prayer. That's rejected. That's what, then they make that cause of action and come here.
What went to the Supreme Court?
Supreme Court, Your Lordships, this Honorable Court passed an order that referred the matter to the Industrial Tribunal. It's a non-speaking order. Supreme Court set aside the order and asked the court to consider the question of delay and the implications of these earlier orders on this present litigation. Your Lordship, these are people who have received it themselves. At 1998, Your Lordship, their prayer is only for employment. Your Lordship will see the prayer is only for employment. In 2017, they file an affidavit. No, this is not paid, that is not paid. 20 years after having received all the compensation of the closure. And Your Lordship, in the closure, IDCOL was asked to make this payment to the, I mean, that's there in the running page 88. Your Lordships.
I'm not clear why, what is this SCAW doing then?
SCAW, Your Lordships, SCAW finally, after, during the, Your Lordships, look at Annexure 2, I think, Your Lordships, with the entire history of the matter is there. Annexure 2.
SCAW industry
Your
has
Lordship,
taken.
Annexure 2. Annexure 2 is the entire corporate proceeding. Your Lordship, SCAW is actually the person, actually,
It is the holding company, madam.
no, you're not holding company.
Yes.
Your Lordship, look at page 16.
Assets and liabilities.
Page 16, Your Lordships, the last portion from 10 lines from the last, Your Lordships, the court passed orders in the miscase number 19 of 2004 accepting the recommendation of Asset Disposal Committee for the sale of the plant, machinery, equipments, tools, raw materials without land and building to Sundaram Fasteners Limited and rupees 6.25 crores and sale 39.39 acres of land and guest house cum administrative buildings to SCAW Industries Private Limited. This is SCAW Industries Private Limited, Your Lordship, who took over some of the assets. Your Lordship, what happened is, when everything closed down, we need 6 people to be there to take in charge. Some managerial people were there, were retained from 1998 till 2005, till SCAW took over. It's those letters only which is writing. SCAW did not even take over those people. And anyways, Your Lordship, any view of the matter is a matter between SN Corporation and SCAW. I was definitely a big creditor. They cannot come back and claim an employment against me. That's what is their prayer. They want to be employed under IDCOL.
All right. Yes, sir.
Madam. I have filed an additional affidavit, madam. That is additional affidavit by person number 1 and 2.
Yes.
In that, at page 30, madam, Annexure 15.
Yes.
This is an expression of interest invited for sale of the assets of SN Corporation Limited, Essential, under the management of IDCOL. So totally, it is managed by the IDCOL, number 1. Number 2, SCAW come to picture because he has taken all the assets and liabilities of Messrs. SN Corporation. Well, now thing is that we are at the premature stage because all these materials to be placed and the decision is to be taken, my lord. But when the matter was placed before the DLO at the liberty granted by this honorable court, then this matter was taken up, consideration was made, consideration fails, and it was reference was made. At this stage, the honorable Supreme Court has intervened in the matter, and at page 49 of my additional affidavit, I have filed the copy of the order. They have also stated, page 49 of my
49
of the affidavit filed by person number 1 and 2. page 49. To appreciate the rival submissions, your lordship got it.
Yes.
To appreciate the rival submissions raised at the bar, we have carefully scrutinized the order passed by the High Court, and we find that the High Court has not really addressed to these aspects. In our considered opinion, the question of delay, acceptance of the compensation, the real impact of the earlier orders, and the applicability of the scheme as submitted by the Learned Council for the respondents. The response means we are their respondents, madam. As submitted by the Learned Council for the response should have been oppositely dealt with by the High Court. Therefore, we are compelled to set aside the order impugned in the appeal. Mr. Rao has submitted that scheme at no point of time is formed by the appellant. Be that is may, all the aspects are kept open to the advocate by the Honorable High Court. So now, the scope was.
Your Lordship, what is the scheme they're talking about? Is the scheme which was submitted before the BIFR for the purpose of reviving the company.
Yes,
That's
yes,
totally a different thing altogether.
Let me submit.
Obviously, Your Lordships, where I was such a big creditor over there, I wanted to make my best effort to revive the company. That was the scheme. It has no application. Your Lordship, look at running page 88. I think that sets the matter. Running page 88. Document filed by them.
Go to the scheme, madam. I have filed Annex 13.
An order which it's a document which remains unchallenged.
At page 20, the scheme is produced, my lord. Annex 13, page 20. At page 24, this clear stipulation is that Essential Corporation has carried out a study to assess the realistic requirement of the different categories of the employees for the proposed capacity utilization level. As per the study, 175 numbers of employees would be retained. Specific scheme is there, my lord. That is why we agreed. The decision was taken at a particular point of time. Thereafter, it was violated. So this scheme I have also produced at Annex 13, page 20 in my
you will get
additional
absorbed
appendix.
where? You will get reinstated where, sir?
At the relevant time, my lord.
No,
because
under whom will you get reinstated?
That is to be decided by the management, my lord. Because management is under control of the IDCOL, my lord.
By the way, Your Lordships, the SN Corporation has been completely struck off from the registrar companies. We filed a document also. Your Lordships, page 88 actually settles the matter. This was an order under the Industrial Act, Your Lordships. What IDC was supposed to do for the benefit, page 88.
Yes.
That this document remains unchallenged, not set aside. Your Lordship, last portion. IDC have agreed during the course of the hearing to pay the closure compensation dues, unpaid wages and contribution to EPF, ESIC of the workmen. Not a single word in the writ. The prayer is also not that. Your Lordships will see they themselves have attached a document which shows that all these dues have been paid. The COPET order also records that all the compensation dues have been paid. And Your Lordships, let them show one piece of document where they have come up to say that this compensation has not been paid. In 2017, Your Lordship, they filed an affidavit saying, these are the provisions of law you should have followed. That's all. Not a single line of word that this is what I was due, this is what I did not get. Otherwise, they would have, in fact, had there been some due, they would have approached under section 33C of the Industrial Tribunal Act. And this order remains unchallenged. They only want job. That's all that is their prayer.
Yes.
And you have also violated the term, the condition precedent before retrenchment. That is Annexure 1. That you have paid the retrenchment allowance after 4 to 5 months.
Yes.
And there is you will also in that respect also I filed decisions, madam.
This is a provision under 25.
If it's violated, then the retrenchment is avenue so void. You cannot pay the retrenchment allowance after 4 to 5 months, madam. And so far the ID Act, limitation will not apply, my lord. So far, my learned friend is
have you received the compensation, sir? Have you received the compensation? He's not answering my question. I don't know why.
Have you received the compensation which was paid?
Yes, my lord.
Yes, it has.
Because now, thing is that at this stage, we have after completing 14 to 15 years of service, now we have been placed in this
Since
stage.
you have received the compensation, how can you claim for reinstatement.
But so, if they are liable to give alternate employment and they have not given, certainly
the compensation has been received by you without prejudice to the claim of reinstatement.
that the compensation, my lord. So, but the compensation, my lord, it is paid after 4 to 5 months. So it is very clear. This has been settled by the.
Sir, when you received the compensation, did you say, I am receiving this under protest and without my prejudice to my rights and contentions that I must be reinstated? Have you said that?
Yes.
Which is the document where you have said, I am receiving compensation under protest?
In spite of the fact that they have received.
Sir, kindly follow the question.
Yes, ma'am. Yes, ma'am.
If you do not want to, then only Justice Patnaik will ask you questions.
Yes, ma'am.
Are you prepared to answer questions that I ask you or not?
They have received the amount.
Show us the document where you have received the amount under protest. Kindly follow the question that is being asked. Did you receive the compensation under protest, saying that this is without prejudice to my right to claim reinstatement?
From the very beginning, yes, you will also be right that I have to ascertain only, will also grant 7 days time. But one thing, before closure also, we have raised the objection and we also filed the review application on behalf of the union. Also, we are raising voice at every stage. From the very beginning, we are raising a voice matter. On behalf of union, review application was also filed. And challenging the closure, we have also filed application before this honorable court.
Orders reserved. We'll reserve orders. Right.
I filed a small deed chat, Your Lordship.
All right. Yeah, we have.
I filed a written note, my lord.
Yes, we've got it.
In fact, Your Lordships will just look at the date chart. It happens to be papers made out of recycled.
Ah, that's why it's that.
It's the same cost.
Okay.
So just in
Very
case
good,
the
very
court
good.
thinks of adopting.
So we are going
that.
to have a new e-filing system from 2nd April.
Lordships.
It's a e-filing 3.0. So it's going to be optional for the entire bar.
Lordships.
So no compulsion, but you might find it so easy that you may all switch over to e-filing.
Lordships, I would be looking forward.
Right.
No, I
It's
said
very
in-
easy. It's
in-
just a 2-step or 3-step process.
No, I said in case also the court feels the need of paper, if they switch to that, it will be a very big help to
Correct,
that.
correct,
It's
correct.
an NGO actually which does it.
All right. Because we have so much waste paper, we can have the recycled paper on this. All right. Very nice. All right.
In fact, it was Mr. Gautam Mishra only who influenced me to actually, look into this. So it's the idea cooked up in both of us' mind too.
All right.
Weekly list item number 22.
It please this honorable.
Yes, please.
So this is a matter pertaining to the year 2011 with respect to non-supply of electricity to the present petitioner. So we have not received any sort of instructions.
All right.
from
Counsel, the
present
petitioner states there is no instructions. This was not. All right.
He has also not complied with the interim order.
All right.
Weekly list item 23.
23 million, no instruction has been
All
received.
right. Same. No instruction.
Weekly list item 24.
24, my lord, I'll apply afresh under the 2011 OTS scheme. Let them consider. That is the only prayer I can make now.
I am for the OSFC million. In 2007,
The
he
interest
also
has-
did not appeal the
Interest has gone up to 2 crores.
Also, in 11 million also he has the failed. Will not comply the OTS proposal. So I have filed additional kindly shift.
Only that scheme
No,
is still
now-
valid.
no, now
I'll
it
apply,
is-
let them consider. That is the
No,
only
I-
prayer.
From my 2011 also, he has availed not availed the OTS proposal million. That is my submission kindly shift page 3. Para. मतलब page 3 para 6 minute was last. Did not pay the settled dues and there is no proper
Oh,
also.
2021 also you availed, sir. You didn't satisfy.
11 also.
All right. It appears from the additional affidavit filed by the OSFC that even in 2021, the petitioner, sorry, even in 2020, the petitioner failed to adhere to the terms of the OTS under the OTS 2011 scheme. As of now, the total outstanding is close to 2.5 crores. It appears that the petitioner is in no position to clear the dues of the OSFC. Consequently, the petition is not entertained, it's dismissed.
Weekly list item 25.
25, I am for the petitioner, my lord. The petition is a government under cooperative society, my lord, running a power loom, my lord. They have taken some loan from the OSFC. And only allegation I could not pay back. OSFC, what without wide publication, sold my property at a lower rate, my lord. This Sonukara has interfered and passed an interim order, my lord. In similar case, I passed an cover order, my lord. In similar case, this Sonukara decided of the same institution, of a similar institution, my lord. They are, without making wide publication, they have sold at a lower rate.
So this is a 2011 order, sir. How much is the amount owed by you?
My lord, it is also 2011 case, my lord.
That's very nice, sir.
Yes,
that you are reminding us of that.
Yes,
I want to know how much is the amount owed by you to the OSFC.
That is, OSFC is not disclosing, my lord. OSFC.
They are very happy that you are not paying them anything.
OSFC.
They are delighted that you are not making them any payment. They are very happy. Are they very happy that you are not repaying anything to them?
They are not, despite our request, they are not disclosing how much their outstanding is pending.
So very good, sir. Then you don't have to worry at all. Just withdraw this petition. We'll record your statement that OSFC is not telling you how much they are to recover from you. And therefore, you are not pressing this petition.
But they have sold the property. They have received the money from this seller, my lord. They are kept in a separate account. They are not.
How much is the money owed by you to OSFC? Who's appearing for OSFC?
Yes, ma'am.
What is the amount due by them, sir? You anyway have to go in for a fresh notice, sir, auction notice. Mr. Das.
It has already been sold in 2 phases, my lord. So for the plant and machinery is concerned, it was sold on 2005, my lord. And that is.
No, we are now in 2011, sir. There is an interim order of 4th May 2011.
Yes. Thereafter, my lord, SBI has approached. SBI is the second charger, my lord. They have approached the DRT. By virtue of the order of the DRT, my lord, although we have sold, the sale proceeds were kept in a separate account, my lord. The direction I have quoted, my lord, annexure A by 1, my lord. My counter.
You're not telling us what is the amount owed, sir?
Yes.
Who is this Utkal Electrochrome Associates?
My lords, I am appearing for the. My lords, I am on VC. I may be permitted to submit. My
Yes,
lords.
yes.
I'm obliged, my lords. My lords, I have filed an intervention application for Utkal Electromed Associates because in the original application, my lords, my authorized representative as individual capacity was made party, my lords, and for which my authorized representative at that point of time appeared and filed the objection, my lords. And my lords, I have filed my intervention application. I am the auction purchaser, my lords. I have purchased by paying the entire amount amounting to rupees 91 lakhs 40,000, my lords. My intervention application is also on record, my lords.
You're not audible, obviously.
My lords, I am audible.
You are audible, sir. I think we are not audible to you.
Sorry, my lords.
What is the property that has been purchased by you?
My lords, the land, my lords, not the machinery, my lords. I submitted my balance sheet. Only the land
building.
Yes, my lords. Immovable property.
How much did you pay for it, sir?
I have paid, my lords, 91 lakhs 40,000.
Already?
Yes, my lord, already paid, my lords. And in my intervention application, I have annexed the receipts, my lords. And if I segregate, my lords, 22 lakhs 85,000 towards the EMD, 68 lakhs 55,000 towards the balance consideration. Along with that, my lords, 71,500 I have paid as an interest for delayed payment also. That has also been received, my lords.
So only possession is not with you now?
Yes, my lord. Possession has not been delivered.
What is the justification for continuing the stay order like this? What is the justification for continuing the stay order, sir?
Not, I want for wide publication and for.
Sir, he has already come forward. He's made such a huge payment.
They have
2011.
They have made payment.
So
to
you know the
OSFC, my lord.
latest law in the Supreme Court. If you want to question the sale, auction sale,
yes,
you have to come up with a better offer, better buyer with a higher offer.
But that's
the law. That's the law.
That is my allegation in the repetition.
Your allegation is not good enough, sir.
But they didn't reply.
No,
they
no.
have not.
Forget all that, sir. You have to reply to the court.
Yes, ma'am.
What have you come up with a better offer with a higher amount, saying I am prepared to pay so much more? You cannot simply question an auction purchase.
Yes, because
unless you're prepared to better the money offered by the bidder.
Yes, yes, ma'am. I got. At the time of in the meeting, they didn't call me, my lord. I was not aware of that sale, my lord. Then now I have to take instruction whether they can.
No. How much is what is the money owed by them? How much do they owe the bank, OSFC? The sale notice itself will tell us. No? What was owed? EMD was 4,02,000.
What is their outstanding? They are not disclosing, my lord.
No.
Total. And out of them, they have sold the plant and machinery for 31 lakhs 50,000. That is adjusted, my lord. Now they have sold the land and building for 91 lakhs 40,000. That part has not been adjusted. It is kept in a separate account.
You say, counsel, the petitioner is unable to tell the court what is the exact amount owed by the petitioner to the OSFC. So stop. Unfortunately, counsel for the OSFC is also not able to inform the court about this. Paragraph counsel for the intervener. Messrs. Utkal Electrochrome Associates has stated in his intervention application supported by an affidavit that the said entity purchased the land of the petitioner in a public auction and paid
and 91
rupees 91 lakhs 40,000. The sale of the land and building of the petitioner and paid rupees 91 lakhs 40,000. The receipts for such payment have been enclosed with the application. It is stated that the said amount was accepted and acknowledged by the OSFC. Stop. Of the said amount, rupees 22,85,000 was towards EMD, rupees 68,55,000 for the balance consideration amount, and interest of 71,500. Stop. Despite parting with such a huge sum way back in 2011, the intervener has not yet been put in possession of the property because of the interim order passed by this court. Paragraph 11, counsel for the petitioner
relies on judgment dated 28/10/2011, passed with this court in writ petition civil 19729 of 2010, bracket, Messrs. Baldev Jew, Powerloom Weavers Cooperative Society versus OSFC, to urge that in similar circumstances, the auction sale, which was without notice to the original borrower, was set aside. Paragraph. The basis on which such intervention is called for, as explained by the Supreme Court in several decisions, including Haryana Financial Corporation versus Jagadamba Oil Mills, AR 2002 SC 834, is only to fetch the best price of the property in question. So, however, the person challenging the auction sale must come forward with either a better offer or a buyer who can make a better offer. Full stop. The petitioner in the present case is not prepared to do either. Full stop. Also, the petitioner is in no position to either make a better offer or bring a buyer who can make a better offer. In the circumstances, the court sees no reason why it should continue the interim order passed by it. Full stop. The said interim order dated 4th May 2011 is hereby vacated. Full stop. Paragraph. The petitioner appears to have borrowed money from the State Bank of India, bracket SBI, which has gone before the DRT, Debt Recovery Tribunal, Cuttack. The proceedings are stated to be pending. Correct?
Yes, sir.
Proceedings are pending the DRT.
Yes.
Are you also a party there?
Yes.
The OSFC is also a party in those proceedings.
OSFC and IPCOL also.
It will be open to the petitioner to pursue any further remedies before the said forum in accordance with law. The petition is accordingly disposed.
May I beg your lordship, pardon my lord, item number 23, I repaid opinion number 4.
Order.
That number recorded. Item 23.
Weekly list item 26.
May I please, Your Lordship? My lord, here I am for the petitioner. I am conscious that it is a matter of 2011, but I have somehow misplaced my file. Somehow I have taken the file of this honorable court and taken note of it. It is an award of 2010 million.
Yes.
This is under challenge.
Yes.
That award, there are two orders is there, madam. One is if at all he is interested to join, then he may be reinstated in service with 25% of back wages, or in alternative, he may be paid 1 lakh rupees.
Has he been served, sir?
My lord, that is the impugned order of the tribunal, which is under challenge. My lord.
Just asking the workman. AD is not back. So you have not served, sir. You have to effect service of notice on opposite party number 2. You have not done that so far.
I'll take fresh steps.
No, not in 2011, sir. All that has to happen by now. You can't keep chasing on workmen after 10 years and 11 years.
On being transferred to Orissa to Calcutta, he didn't join in that new place of posting and remain absent. For that purpose, they are saying that he has been terminated from service.
Right.
That is at Exhibit A, A1 and B.
Yes.
So the writ application. Man.
Yes. How old was he?
Possibly, I don't have any information, my lord. It's a courier company.
During the 11 years of pendency of the present petition, no effort has been made to actually effect service of notice on the opposite party number 2 workman. First up, on the last occasion, full stop. This is despite notice having been issued on 16th May 2011 by this court, on which date the operation of the award was stayed. Paragraph. The AD card is yet to be received from opposite party number 2. Stop. In the circumstances, the court does not propose to grant any further indulgence to the petitioner to effect proper service of notice on opposite party number 2, since this is already 11-year-old matter. Petitioners are accordingly dismissed for non-prosecution.
And that award, so far the award is gone, let it be decided on merit by that.
Okay, sir. Not inclined.
My lord, that has not been taken care of by the learned tribunal. When the petitioner himself is the, I mean to say the workman
Is there
not-
any 33C2 proceedings instituted by the workman? No.
Now here, my lord, the petitioner is the management.
No. By the workman, sir. Has he instituted any proceedings under 33C after the award?
No, my lord, so far.
So you don't have to worry anything then.
Or else, my lord, may be given a chance to send notice afresh.
Not at this stage, sir. Not after 11 years. Yes.
Weekly list item 27.
Again, see postal requisites for issuance.
My
of
lord,
notice.
this matter, no instruction.
No instruction disposed of.
Weekly list item 28.
28 also no
No
instruction.
instruction. All right.
Weekly list item 29. 29.
More detail.
None appears dismissal non-prosecution.
Pardon, Lordship, item 28 is my item, Lordship.
Yes,
I
carry on,
thought
sir. You never-
28 is mine, 27 is mine. I have taken note of that, 28 is also mine, maybe.
Weekly list.
Oh, supplementary, he is meaning supplementary. 28 is weekly list, my matter, no instruction.
Weekly list.
27 and 28.
Weekly list item 29.
Petitioner is challenging the award passed by the London Labour Court in spite of
Sir,
observing
you have
that
not served the opposite party, sir.
My lord,
You have not served the opposite party. Anyone appearing? Nobody's appearing. Is item 28 or 29?
29.
29. You have not served the opposite party in all these 11 years. Despite issuance of notice way back on 8/11/2011, no attempt has been made to actually serve copy of the notice on opposite party.
I may be permitted to
Management.
take notice, my lord, of this.
This court does not propose to have notice issued at this stage, particularly this is since this is an 11-year-old matter. The petition is accordingly dismissed for non-prosecution.
And only our London Court below has observed that neither is the termination is illegal and justified, my lord.
You have to
Only
serve
awarded
the other side.
10,000 rupees. my lord.
Without service on 11 years, you can't take to serve the other side. Yes.
Weekly list item number 30.
May I please, my lord, I'm on. Well, the matter is infructuous, my lord. It's
All
very.
right. Petitioner stays
Matter will be withdraw.
infructuous.
I pray for withdrawal.
Disposed of as such.
Weekly list item 31.
And in this case, I am appearing for the petitioner. I filed him for a date chart along with submissions, my lord. Lots of kindly. Please.
My lord, before the counsel for the petition proceeds, I want to submit that he has challenged the land acquisition proceeding with regard to opposite partner number 8 company, my lord. And in the meantime, opposite partner 8 company has before the NCLT and the resolution professional has already been appointed. So this petition
and proceed. Yeah. Opposite party number.
Lordship, there is an interim order. So your lordship may kindly protect the interest of the
There's no
petitioner.
question, sir. We can't pass any orders. Now you have to go to the NCLT. That's the law, sir. Now.
My lord. I'm appearing for ITCO, my lord.
All right. Counsel for the opposite party number.
8 my lord. 8 my lord. 8. Again 8. 8.
Sorry. Opposite party number 8 informs the court that OCL Iron and Steel Limited is now before the National Company Law Tribunal in proceedings instituted under the Insolvency and Bankruptcy Code. The court is informed that the NCLT has passed an order appointing an insolvency resolution professional in the said case. In that view of the matter, no further proceedings against the said company can proceed in any court. The petition is disposed of with the petitioner being permitted. With a full stop, the petitioner will have to approach the NCLT for appropriate leaves.
My lord, the land action proceeding may continue.
No, I don't think any proceeding can continue, sir. That's the.
Because we have already deposited 86 lakhs as per the direction.
Whom are you for, sir?
I am for the ITCO, my lord.
ITCO is different. Yeah.
Yes.
We are now on OCL Iron and Steel. All right.
But we have acquired the land for IDCO. IDCO in turn will give it to OCL also.
Yes, ma'am.
Anyway, OCL is now in liquidation, sir, in the company law tribunal.
Weekly list item number 32.
32, my lord, it has no instruction.
No instruction.
32, I am appearing for OP number 6.
All right.
Copy in 32.
And 32, I am appearing for OP number 1.
And 31
All right.
copy.
All right.
Union of India.
No instructions disposed of. Right.
Weekly list item 33.
None appears dismissed non prosecution.
Weekly list item number 34.
So I am from Nawab, sir, OPD 6 and 7, sir.
All right. None appears to the petitioner. Dismissed non prosecution.
Weekly list item number 35.
None appears dismissed non prosecution.
Weekly list item number 36.
Item 36, the way the London Tribunal has passed the order at page 26.
So AD not returned
Madam,
from 1, 2, and 3. OP number 5 not served. Whom are you for, sir? Anyone appearing on the other side?
I'm for the state.
So not most of the respondents not served, sir.
Yes, madam. Yes, madam. They have not come. I'll take a
No, not at this stage, sir.
press steps.
No. Not in 2011 matters. See, the past 11 years, no steps were taken to have notice served on the opposite parties.
My lord, may I submit?
Yes.
Madam, kindly come to page 36. On that count, it can be disposed of. Page 36. The tribunal has opined the respondents have taken the very same stand. They were selected temporarily and the posts were not intended to be filled up permanently. The post was not a single post.
All right. You see, yeah, having examined the impugned order of the tribunal dated 21st October 2009, the court is not satisfied it suffers from any legal infirmity. Full stop. The conclusions of the tribunal, as recorded in para 9, read as under Tribunal 36-37. There is accordingly no merit to the present petition. It's dismissed as such.
Weekly list item number 37.
May I please know? The opposite party, as a consumer, made an application to the licensee under regulation 1110 of the OERC distribution code supply code 2004, my lord. That says, my lord, if there is a breakdown because of damage and destruction caused by 107 of that regulation, which refers to force majeure condition, then certain benefits are given to the consumer, my lord. So the breakdown is the consequence, my lord. The breakdown must be because of damage and destruction of the plant or premises due to regions referred to in 107, my lord.
Who's for the other side, sir? Have you served the other side?
Yes, my lord.
Yes, I am happy.
All right.
Well, I'll read 1010, my lord, of the regulation, my lord, because there are two regulation, my lord, which are important for your lordship to decide the issue, my lord. 110 said, my lord, at any time during the continuance of the agreement between the licensee and the consumer, the plant or the premises of the consumer is destroyed.
So 1 minute, who is appearing for Mahanadi Casting Private Limited? Have
Yes,
you served
I am
them?
happy. I am appearing.
Ah, all right. Yes. What was the order passed by the
GRF? GRF held that, yes, there is a breakdown, but there is no finding to the effect that what is the cause of the breakdown, my lord? Because the cause of the breakdown will entitle somebody to avail the benefit under 1010, my lord. Merely a simple breakdown will not entitle somebody to have the benefit, my lord. So it's a exemption clause, my lord, which has to be interpreted strictly because it amounts to an exception, my lord. The clause says breakdown. Breakdown is the consequence, but breakdown for what reason? Breakdown is the consequence. The cause is destruction and damage of the plant and premises due to regions under 107, my lord. Under 107 specified what are the force majeure, my lord. I'll read that, my lord. I'll first read 110, my lord, because that is the basic regulation on which the benefit is claimed. At any time during the continuance of the agreement between the licensee and the consumer, the plant or premises of the consumer is destroyed or damaged due to force majeure conditions referred to in regulation 107 or 108, resulting in breakdown or rendering the plant or the premises wholly or substantially unfit for occupation or use, the consumer may give 7 days notice in writing to the engineer of such breakdown or unfitness, take a reduced supply, my lord. He'll take a reduced supply, so there will be less billing, my lord. You also may see an extra one.
What is the amount involved? When you revise the bills, what happens? Under the impugned order, you are supposed to revise bills for July and August 2011.
No, that's true, my lord. But what I'm saying,
what is the amount involved?
The amount involved would be around 5 to 6 lakhs only.
Lakhs. Oh, I see. All right.
Your also may see an extra one is application, my lord.
No. So this order has got stayed by this court.
Yes, my lord.
So what is the result of that?
And after that, my lord, he applied. We said instead of 1010, you applied under 68. He applied and we have granted also.
All right. Then
68 he has applied and we have granted. We said it will not come under force majeure. Normal circumstances, you can apply for reduction of load factor, which he applied. And 2013, we have reduced the load factor, my lord.
They have reduced the load from January 2013, but from the date of breakdown, that is June 2011 till December 2012, they have not revised the bills due to pendency of this situation.
Yes. On who's responsible for the breakdown, sir, according to you? Who's responsible for the breakdown?
In extra one, he has stated the reason, my lord. In extra one, page 7, my lord. It is to inform you that there is a major breakdown of the main induction furnace of our plant. No reason has been assigned for why there was a breakdown. Because the reason of breakdown has to be in accordance with 1010.
According to you, what is the reason for the breakdown? According to you,
well, he will say not. It may be normal breakdown, mechanical failure.
Maybe. Why are you saying maybe, sir? When you send your team, you are the electricity company.
But my lord, he is making an application. Sir. See, onus is on him to prove that it was because of 107, my lord. Onus is on him to discharge that yes, because of the condition enumerated in 107, there is a breakdown. Your lordship may see 107, the condition has been specified. 107, I'll read, my lord. The licensee or the consumer shall not be liable for any claim for loss, damage, or compensation whatsoever arising out of failure of supply when such failure is due either directly or indirectly to war, mutiny, civil commotion, riot, strike, lockout, fire, flood, tempest, lightning, earthquake, or other force, accident or cause beyond the control, my lord. If it is any cause beyond the control, then he has to say what is that cause, or whether that cause was beyond his control or not. He has to specify, my lord.
Let's see what he says in his reply. Come to page 11, internal page 11 of the counter.
Yes, madam. Counter affidavit filed by the other side. Yes.
Page 11 is para 4B.
Yes.
Just read that.
As regards the amendments made in para 2 of the writ petition, it is stated that while the opposite party unit was running smoothly, on 20th June 2011, suddenly there was a major breakdown of the main induction furnace, rendering the plant completely unfit for any production activities, since the immediate repair or replacement of the said furnace was not possible, which always depends on the availability of the service engineer, spares, or
So even here they are not saying it is because of any of those reasons.
Hello?
They are not saying it is because of any of those reasons which you just read out.
Yes, my lord. Yes, my lord. Because regulations say due to conditions referred to in 107, my lord. Force majeure condition referred to in regulation 107. So it is very specific.
What do you say, sir? How do you say the breakdown is?
In my complaint petition before the GRAF, that they are not annexed with the writ petition. I have annexed it along with my counter. In my complaint, I have mentioned that the breakdown of the furnace was accidental and due to beyond reasons.
So that is all very vague, sir. 107 requires some specific factors to be fulfilled.
107 says,
let's take where's regulation
along with other causes, my lords, directly or indirectly due to accident or cause beyond his control. So, directly or indirectly, that is the language.
Just see 107. You're reading 107.
The licensee or the consumer shall not be liable for any claim for loss, damage, or compensation whatsoever.
1 minute. 1 minute. Distribution, is it? Where is this? What's the title?
Conditions of Supply Code 2004.
And 107 in that, is it?
Yeah.
Yes, sir. 107 reads something else, sir. Distribution conditions of supply code, it says, but the actual thing is.
Now, she may take my book.
It is the mobile report. Mark of City good day page dita coach.
Oh, something is completely different. Force measure is here, but that's very different. 195, 196. What is this? What is this? I'm not able to understand. This is 2019.
Yes, ma'am.
Oh, this is 2004.
2004.
All right.
107. The licensee or the consumer shall not be liable for any claim for loss, damage, or compensation whatsoever arising out of failure of supply when such failure is due to either directly or indirectly to war, mutiny, civil commotion.
So where is that? What is that to show even indirectly it is due to any of this?
My lords, So that also includes accident or cause beyond his control. My lords. Then
No. All this must be beyond your control.
Yes, or maybe due to maybe accidental.
No, not maybe. See, there is no accident. What is accident?
Yes, my lord. Other force accident.
What was the accident that took
The
place?
breakdown of the machinery was
That's
itself
not the
accidental.
result. I'm sorry. Don't mix up the result as the accident itself. There should have been an accident as a result of which there was a breakdown. There should have been a riot as a result of which there must have been breakdown.
And what the GRF
That riot, that accident, that lockout, that fire must be beyond your control. Where is that accident which took place, which was beyond your control, which resulted in the breakdown? That is what you have to explain.
Because the GRF has factually gone into the matter and after
So which
examination
is
of
what
the-
is challenged here, sir. There's no point in going back to GRF.
No,
Unless you satisfy this requirement, you
GRF
can't
has
take
already-
advantage of 107.
GRF has already examined those aspects. I am placing the GRF's order, the fact-finding authority matters. That will be at page 19 of the writ petition, GRF's order.
All right.
Para 5. From the reading of regulation 107 and 110 of the code, what we understand that if the plant of the consumer is damaged or destroyed due to force majeure conditions referred to in 107, which includes earthquake or other force accident or cause beyond his control, resulting in breakdown or rendering it wholly or substantially unfit for use or occupation, a consumer may request the engineer for supply at reduced load. Here the complainant is a power intensive large industry where bulk of the power is consumed for the induction furnace. During the course of hearing, it is revealed that the capacity of the said furnace is 350 kilowatt and the complainant is engaged in manufacturing of grinding, medieval, manganese casting and job plates, etc., which cannot be manufactured without operation of the furnace, which is said to be damaged on 26/2011, resulting in complete stoppage of production activity.
This has nothing to do with the stoppage of electricity. Your furnace broke down, so your production activity stopped.
Then the GRF relied on the decision of 1961 Supreme Court.
Decision will come to in a minute, sir. What about the facts? Where is the factual determination by the GRF that these conditions in 107 was fulfilled? Where is the factual finding on that?
So GRF held that it was accidental and due to reasons beyond the control of the
Sir,
company.
that accident, which is the accident the GRF is referring to?
Minus. And the GRF relied on the decision of the Supreme Court. That is the one where clearly the Supreme Court observed that breakdown of machinery is included in the within the meaning
breakdown of machinery is your furnace. That furnace has nothing to do with the electricity supply. Don't confuse things, sir.
And breakdown of machinery, that is connected because of 110, because during the course of when the plant becomes defunct for some force majeure reasons, conditions, or becomes unfit for production, then the consumer may request for a reduced supply. And why there is such provision, my lords? Because, for example, the complainant has a
You're not answering the question, sir. I think you don't want to answer or you've not understood.
Yes, your lordship is asking whether there was any reason for that breakdown, which the GRF has examined or not.
No, there are two kinds of breakdown here. Like I am having a printing factory.
Yes.
My printing machine breaks down.
Yes.
So the production comes to an end. Yes. That is not the breakdown you're talking here. For non-supply of electricity, what should be the breakdown is the question here, sir.
No, minus. That is that.
Yes, yes. 107 is that kind of breakdown, sir.
Minus. 107 minus.
It is not. Whatever, you may have a printing industry, you may have a chemical industry, you may have so many plants and machinery which will break down.
I will clarify.
That does not stop the power supply breaking down, sir. Power supply will stop when a transformer goes bust, from some fire happens in the transformer, some short circuit happens. That is the accident they're talking of in 107. This is electricity code. This is not a Factories Act.
I am clarifying it. So far as 107 is concerned, that is force majeure conditions for supply of power to protect the licensee.
This is exactly what I'm telling you.
Yes, my lord.
You are mixing it up with your own factory's problems.
No, my lord. No, my lord. I am coming.
Whether your furnace broke down or not is not the issue here, sir.
110 takes care of it because
110 only enables you to ask for a reduced load if your machine breaks down.
Let me read out the exact thing and the objective behind 107 and 110. My lords. 107 saves the licensee from any claim or damages or compensation by the consumer in case of failure to supply power in the force majeure occurrence of force majeure events. So similarly, 110 saves the consumer from paying the entire amount for the contracted demand if there is any breakdown caused due to force majeure events mentioned in or prescribed under 107. So while 107 protects the licensee from any compensation or damage claimed by the consumer due to his failure to supply, 110 saves the consumer also equally to prevent him paying excess charges.
What was the accident that caused this breakdown? You tell us. What was the accident? What was the accident? Even for 110, what is the accident which took place which caused the breakdown?
Breakdown itself is an accident.
No, please, sir.
Because there.
No, you're completely mistaken on this.
That is
you're completely mistaken on this, sir.
So, if Lordship permits, I may be allowed to permit. I have given the citation of the 61 Supreme Court, and the Supreme Court.
Sir, judgments cannot give factual answers. Where is 81?
Supreme Court said breakdown of machinery is included in the meaning of force majeure. So thereafter, I don't think it would be required to go into the cause of breakdown.
Of course, you have to, sir. Unless you demonstrate the cause, this question of who's responsible will not arise. That cause must be beyond your control. That's the test.
That is the Dhandasmal Govindram decision at the first decision set. Paragraph 19 is relevant. May I please para?
Yes, please.
19.
Yes.
Of the Dheeraj Malda.
Yes.
McCarty judge in Libupin versus Crispin, so-and-so has given an account of what is meant by force majeure with reference to its history. The expression force majeure is not a mere French version of the Latin expression vis majeure. It is undoubtedly a term of wider import. Difficulties.
So this is not a self-certification. Let me tell you this. This kind of discussion which you find in para 19 is not because somebody self-certifies. I cannot pick up a piece of paper and say my machinery is breaking down for reasons beyond my control. Therefore, now don't charge me. You get my point? Have you followed what is being said?
Yes, sir. But the next two lines.
Sir, factually, even in these two lines, it does not mean that somebody. He's busy reading. I think he's not prepared to listen. Whenever you have time, we'll ask you the question, sir.
No, my lord, I'm listening to you. I'm listening.
You cannot pick out a piece of paper and write on it my machinery is broken down due to accident, therefore do not charge me electricity. That will not satisfy the requirement of the law, sir. Are you understanding what I'm saying?
Yes.
Even if you write, my machinery is broken down for reasons beyond my control, you're writing on a piece of paper, that sentence will not satisfy the requirement of the law. There's something called proving it.
So proving question will arise. My humble submission is proving that question will arise. What I am required under 110 is just to inform
No.
licensee
Sorry.
that there is
Sorry.
a disruption of
Sorry,
production
that
activities
understanding
due
is
to
totally
breakdown.
wrong. That understanding is totally wrong.
So it is the
That
licensee
is
who will
totally
cause
wrong.
inspection to find out.
Nobody is going to accept that. You can keep writing 10 letters, 10,000 letters also. Your electricity company will not agree with you. They'll want to show you, tell you, prove it. So when they refuse and you go before a forum, in that forum you have to still prove it. Just sitting back, I have written to you, now you have to do it. No question. If you are claiming that your machinery broke down for A, B, C, D reasons, which were beyond your control, you have to prove it.
They never, before the forum also, they never disputed that, they did not raise that contention even.
What?
That there is no cause behind it. They said it is not due to proper annual maintenance. They took a contradicting stand. On the one hand, they said the breakdown is due to non-maintenance. And on the other hand, they say it is not breakdown, it is annual maintenance. For which there is
either way, sir, they're not admitting that 107 factors existed. They're not admitting that 107 is attracted at all. There's no such admission. All right. You see,
because my lords, the objective behind 100, what your lordship. So the difficulty is that why these provisions has been incorporated, because my contract.
There are so many ways of proving, sir. Let's say there's a massive power outage.
Yes.
In the whole of a city. Not only your industry, your neighboring industries also experience a 10-minute blackout. Then you can say all our machinery stopped functioning during this time, and I'm producing affidavits of 5 of the industries.
No, my case is not that. Due to
I'm giving you an example. Okay. Sir, please try and understand. Anyway, I think you people don't understand how to engage in an issue, sir. It's a sad part.
Sorry.
You have to test you have to test an argument by examples, right? All right. Anyway, I should not be wasting my breath. Yes. What else, sir?
Since on merit your lordship is not convinced, so I do not also like to press the question of maintainability of the writ petition because I do not want to succeed on that mere technicality. Though I have taken a detailed plea of maintainability of the writ petition also, I do not want to press it.
All right.
Because I do not convince your lordship on merit. So I do not want to succeed on that point.
All right. You say the executive engineer, Central Electricity Supply Utility, bracket says so. City Distribution Division 2, Badambadi Cuttack has filed this petition, questioning an order dated 29th September 2011, passed by the Grievance Redressal Forum, Sesu Cuttack, accepting the plea of the opposite party complainant and ordering Sesu to supply power to the opposite party at a reduced load of 50 kVA from July 2011 onwards. And during the period of such reduced supply, to raise electricity charges bills in terms of regulation 110 of the OERC, distribution
bracket conditions of supply, bracket code 2004, bracket hereafter, single quotes code, close bracket. Full stop. It was further directed that the bills already issued for the months of July and August 2011 should be revised within 15 days of the receipt of the order. Full stop. Finally, it has been ordered that till such bills are served on the complainant, that is opposite party herein, power supply to the premises of the complainant shall not be disconnected. Paragraph. While directing notice to issue in the present petition on 2nd December 2011, this court stayed the operation of the impugned order of the GRF. Full stop. This court has heard the submissions of learned counsel for the parties. Full stop. Today, learned counsel appearing for the opposite party has handed over a counter affidavit filed by a counter affidavit. Full stop. The principal contention of the counsel for the petitioner was that the GRF misconstrued the scope and ambit of Regulation 107 read with Regulation 110 of the code, both of which read as under. Reproduce 107 followed by 110. There's a black page. Paragraph. Counsel for the petitioner submitted that since the consumer came forth with a case of breakdown of machinery on account of accident or cause, single quotes, beyond his control, unquote, then even for the purpose of Regulation 110, he was required, the burden was on the consumer to show that the breakdown was for such reason. Full stop. The failure of the consumer to discharge that burden would disable the consumer from claiming the benefit under the provisions under Regulation 110. Full stop. In other words, his contention was that in the present case, apart from simply stating that there was a breakdown of machinery in the consumer's factory premises, that no attempt was made by the consumer to actually demonstrate that the said breakdown was on account of any of the causes mentioned in Regulation 107 of the code. Paragraph. Counsel for the opposite party consumer, on the other hand, referred to the counter affidavit, which states that there was a major breakdown of the main induction furnace, which rendered the plant completely unfit for any production activities. Stop. According to him, this by itself is sufficient to attract Regulation 110 of the code. And the electricity company was obliged in law to accept such a statement of the consumer and reduce the power load factor apart from revising the bills for the period of breakdown. Reliance is placed on the decisions in Dhanraj Mal Govindram versus Shamji Kalidas and Company, AIR 1961 SC 1285, and Executive Engineer Sesko/Sesu Kendrapada versus Grievance Redressal Forum Cuttack 2008, supplementary to OLR 913. At the outset, it must be said that although the last mentioned judgment was cited by counsel for the opposite party to question the maintainability of the present petition, during the course of the arguments, he did not press that point. Paragraph. However, learned counsel for the opposite party drew attention to the following passage in Dhanraj Mal Govindram Supra reproduce para 19, A to A. Counsel for the opposite party accordingly submitted that in the present case, the requirement of Regulation 110 read with Regulation 107 of the Code stood satisfied with the consumer having stated that there was a major breakdown of the main induction furnace, rendering its complete plant unfit for any production activity. The court is unable to agree with the above submission made on behalf of the consumer / opposite party. A careful read of Regulation 110 read with Regulation 107 would show that the requirement for attracting the single quotes force majeure clause is that the breakdown of the plant and machinery, rendering it, open quotation, wholly or substantially unfit for occupation or use, unquote, must be as a result of the factors, any of the factors enumerated in Regulation 107. Full stop. In other words, it should be shown that such failure is, open quotation, due either directly or indirectly to war, mutiny, civil commotion, riot, strike, lockout, fire, flood, tempest, lightning, earthquake or other force, accident or cause beyond his control, unquote. The breakdown itself cannot be termed as an single quotes accident. So in other words, the breakdown must be as a result of the accident or as a result of some other cause which is beyond the control of the person in whose control the plant operates. Full stop. The breakdown is the result. Full stop. Regulation 107 talks of the single quotes costs, unquote. In the present case, while the consumer has asserted that there has been a breakdown of the plant and machinery, the consumer has failed to demonstrate what caused such breakdown on plant and machinery, and that cause was relatable to any of the causes mentioned in Regulation 107, and that such cause was beyond the control of the consumer. Full stop. Without discharging this burden of proof, it is not possible to agree with the consumer that Regulation 110 read with Regulation 107 of the Code is straightaway attracted by the mere statement by the consumer that there has been a breakdown of its plant and machinery. Paragraph. In that view of the matter, the impugned order of the GRF, which fails to examine the actual requirement of Regulation 107, read with Regulation 110 of the Code, cannot be sustained in law. The order of the GRF is accordingly set aside. Paragraph. The Court has been informed that from 2013 onwards, pursuant to an application made by the consumer, its load factor has in fact been reduced to 68 kV. And therefore, the dispute, if any, was only confined to the period between 2011 and 2013. Full stop. In any event, in view of the reasons discussed herein before, the Court is unable to sustain the impugned order of the DRF and hereby sets it aside. The petition is allowed in the above terms, no orders is to cause.
Your
Well,
lordships have
item
called
one.
out item
one.
Item one.
Orders.
Your lordships on the last occasion
Item one,
directed.
Whether you can have him as a sole arbitrator.
My lords,
my lord,
my instructions
I'm agree
are,
with
my lords, my instructions, my lords, are that we'll appoint an arbitrator, nominee arbitrator, as the matter was being proceeded with.
You only delay
And
matters further. All right. While counsel
I'm
for
sorry, my lords,
while
that's
Mr.
what my
Sarangi
instructions
counsel
are.
for the opposite parties. All right. While Mr. Sarangi counsel for the opposite party states that the Paradip Port Trust has no objection to Justice Mahapatra being the sole arbitrator. Mr. Acharya, London Council of Petitioners and Instruction states that they would prefer going with the full arbitral tribunal, full 3-member arbitral tribunal. Stop. That was the matter. On or before 2nd May 2022, both parties will nominate their respective members of the arbitral tribunal, and the
My lord,
3-member tribunal.
my lord, we will continue with our old arbitrator.
All right, whoever.
In that event,
Inform Justice Mahapatra of the names in that regard. Justice Mahapatra will then convene the meeting of the arbitral tribunal for its first sitting as soon thereafter as is convenient to him and the members of the tribunal and the parties. The arbitration is requested to be completed within a period of 6 months.
my lord,
My lords,
all right.
As your lordship feel.
All right. A copy of this order be immediately delivered by the special messenger to Justice D.P. Mao.
my lord, another thing, my lord, in this, the central government has constituted the Indian Ports Association, and they have constituted a committee for early disposal of the settlement, conciliations and settlements. Can you go to that also, if he agrees?
That Mr. Acharya has to decide.
My lord, on 4th May 2021, the Indian Ports Association has constituted a committee constituting the Sri Gopal Krishna, former Secretary, Ministry of Ports, Sri N. Civilasan, former Special Secretary, Logistics, Ministry of Commerce, Dr. A. Balasubramaniam, Senior Director, Project Finance, Development Finance Corporation Limited. Constitutes this committee is considering all the grievances of the contractors. So in that event, if he can go to them, it can be disposed of at a early stage.
My lords may keep that option open, but your lordships may pass that effective order that your lordships have already dictated. Keep that option
This will
open.
not prevent that from happening, Mr. Sarangi.
Yes.
Can you mention this about this order, my lord? If at all possible.
My lords, that may not be required, my lords. That's anyway, my lords, the party can always explore different ways of settlement, my lords, at any
Let's
stage.
confine this to the application here, Mr. Sarangi.
My lord, my only predicament is that my client has instructed that this may be put to the notice of the court. For that reason.
No, it has to be more to the notice of the party. See, I cannot compel a party to go to that forum, sir.
No, I am not saying that.
So it has to be basically brought to the notice of the party. You have brought it to his notice. That is fine.
Yes,
if at all he agrees, then in that event we will go there.
Yeah, if he agrees, he'll let him take instructions on that. No, we don't have to. That's not scope of this petition, sir.
No, my lord, for my
No.
My client has instructed in like manner.
That's all right. It's all right. You said the IA is disposed of in the above terms.
Grateful, my lords. Great.
Orders item number 2.
Milord, in this ARBP petition, the petitioner is approaching this honorable court for appointment of arbitrator to
adjudicate the dispute between the parties.
So
my
these
lord.
defects 9.1 and 9.2 are not
My lord,
removed.
I am undertaking to remove the defects, my lord. But in the IA, now they are taking a serious action against me to really to seize the vehicle, my lord. Status quo be maintained till.
That you can go for section 9, sir, not in a section 11. This section 11 is only for appointment.
Lord.
For interim orders, you have to file an application to section 9. Anyway, I'm giving you free legal advice. All right. You say counsel for the petitioner undertakes to remove the defects within 1 week. Subject to the removal of such defects, notice be issued to the opposite parties. Returnable 29th April. Right.
weekly list, item number 38.
Item 13, first item, I am for the petitioner Miller. In second item, I am for this opposite party.
All right.
Sir, in this case, the award is of the labor code is under challenge, Miller.
All right.
That the workman, while working as salesman in sale counter in Chaudhar municipality, has misappropriated about of rupees 43,980 and 53 paisa, for which the department proceeding was initiated, and also FIR was lodged. And in the department proceeding, the charges were established, and the second so-called notice and the inquiry report was sent to his address. And though he received the second so notice, but didn't choose to reply anything, and subsequently the disciplinary authority dismissed from service. After dismissal from service, after 4 years, in criminal case he was acquitted. Thereafter, after lapse of 22 years, in the year 2006, he raised the dispute before the LC, and after failure of concession, the matter was referred to the London Labour Court, Bhubaneswar. In the after the receipt, the workman filed the claim statement, but they have not whispered about that he was dismissed on the ground of on the basis of the dismissal proceeding. So after this, the management, after received the notice from the London Labour Court, he filed an application. He approached the Honorable Court in WPC number 10621 of 2009, challenging on the ground, challenge the order of reference because this is a stale one. So the Honorable Court, while order dated, I have quoted that order at page 4, Miller. At page 4 of a writ petition, and the Honorable Court directed to file a petition before the adjudicating authority, raising all these points that the documents are not available, and in the meantime, the inquiry officer who will substantiate the inquiry report, he has been died in the meantime, and material witnesses have been transferred and also retired. So, this point, the management filed a petition before the London Labour Court after direction of this Honorable Court, and the London Labour Court recast the issue that while Annexure 3, that is at page similar, that whether the reference is mental or not. So accordingly, and the workman deposed in this case, and the management witness, the executive officer also gave evidence. In the workman has never stated in his examination chief that he was dismissed on the basis of the department proceeding, and he only agreed and he admitted in his cross-examination, Miller, that he was dismissed on the ground of on the basis of the department proceeding, Miller. That is Annexure 5, page 28. Let's turn to page 29, Miller. Initially, he was appointed as a sweeper, but performed this duty of sales center, selling the articles. I was dismissed from service by way of inquiry, but I was not supplied with the copy of the inquiry and dismissal order. I also participate in the inquiry as I was not given the scope to participate in the inquiry. This fact is not correct, Miller. He has given 5 chances to attend the inquiry. That inquiry report also exhibited at exhibit G, Miller. Exhibit D. The inquiry report, the inquiry category stated that in pursuance of notice to appear before the undersigned, the delinquent personally produced an application on 18/12/81 to be allowed to go through the records relating to his sales center accounts in the municipal office. But the delinquent did not turn up to peruse the records, even in 3 dates were fixed. for the purpose. It is clearly implied that the delinquent had no sincerity to going through the records, but he was simply taking plea to cause delay in the inquiry. So the delinquent was informed by a registered letter on 27/2/82 to attend the inquiry on 4/3/82 at 10 a.m. in the office of the undersigned. Failing with the inquiry would be decided expecting. But the registered letter could not be delivered to the delinquent in spite of the postman's visit to his residence 6 times, and hence the said letter was returned back to the undersigned by the postman on 12/3/82. Thereafter, again another letter fixing of the date of inquiry on 5/4/82 at 10 a.m. was sent to the delinquent by the office peon twice on 23/3/82 and 24/3/82, but it could not be delivered on the delinquent was absent. At last, a notice was published in the Delhi Samaj on 12/1/83, fixing of the date of inquiry on 21/1/83 at 11 a.m., clearly indicating that if the delinquent failed to attend the inquiry would be decided expecting. In spite of that, he has not attended the inquiry. And before the Law and Labor Court, the management categorically stated that this is a stale claim and all the documents are not available, though he has filed 3 to 4 documents. One document he has filed as stated in his award. That is at page 22, Miller. Award starts at page 17. Page 22, my lord.
Yes.
According to MW1, a domestic inquiry is conducted against the workman on the ground of misappropriation of fund amounting 43,990 and 53 paisa while performing as a salesman in the sale counter of the management, and he was suspended from service, and charge sheet was issued on Exhibit A. Is a Xerox copy of the suspension order, and FIR was lodged against him for such misappropriation by Exhibit C. The special audit was conducted. In the audit report, liability was fixed to 43,990 53 paisa. Exhibit B is the Xerox copy of the audit report. The inquiry was conducted in absence of the workman, and inquiry officer submitted the report by the Exhibit B. A copy of the inquiry report and the so-called notice was sent to the workman through messenger, but the workman did not receive and subsequently it was sent by a registered post, which was received by the workman via postal ID Exhibit Z. The workman neither filed any so-cause nor appeared in the inquiry proceeding, and on the basis of inquiry report, the chairman of the management dismissed the workman from service via Exhibit H, and it was communicated to the workman by registered post, and it was returned back with postal remark address absent by J. But on perusal of Exhibit J, it shows that initially the workman was absent and later on it was refused to receive the same. Further, the MW1 deposed that due to delay in raising the dispute by the workman, the material witnesses are in the meantime expired and some of them retired from service. The relevant documents are the day-to-day proceeding of the inquiry application.
All right, sir, let us ask the other side. Yes. What do you say, please?
My respectful submission, two delinquents were there. This is a sweeper and another was also class 4 employee. And inquiry, absolutely no inquiry has been held, and I was dismissed from the services. And thereafter, my lord, reference has been made, and on acquittal, other one has been reinstated, except I am not reinstated. And I came to reference, and that award was passed, giving instead of compensation, reinstatement and back wages, they have quotas awarded compensation of honors. That is the case. Reference, absolutely there is no inquiry, and other man, they have reinstated the other man along with this after the acquittal. The award is
that other person, Miller, he has filed an appeal before the government, and appeal, the government decided and he deposited the misappropriated amount. But he didn't. This workman didn't choose to file appeal.
What is the inquiry?
And
this is also Annexure 1. Annexure 1 is also the letter of the government to reinstate the request, the detailed report in the matter to please be furnish department 5999 positively and for reinstatement. This is annexer 1 and annexer 2. This is the letter of the government.
My lord, in this case, I filed 2 judgment Miller of the surface code Miller. That is about the stale claim. In case of stale claim,
Correct.
that is 2007 Supreme Court 1848 Miller.
All right, sir. We'll look into it. We'll incorporate it.
Para 20,
all right.
Para 27 Miller.
Yeah. Anything else you want to say, sir?
No, nothing.
All right.
Nothing.
The petition is allowed. We'll pass the detailed order. Right.
Weekly list item 39.
The 30555 is allowed. 28712 is dismissed.
I beg your pardon, my lord. On behalf of Mr. Bose, there is no instruction in item number 39, my lord.
Well, I'm for the opposite party selection of the year 2008-9.
Yes. All right.
Weekly list item 40.
The conducting council has died in this matter. I pray for 1 week time I will take instruction. On request only I.
No. When did he die, sir?
His clerk has.
No. Don't just simply walk in like that, sir.
I have no power in this case. Then
don't.
I'm not associate also.
None appears dismissal not prosecution. All right.
Weekly list item number 41.
I am for the opposite pet number 3.
None appears dismissal not prosecution.
Weekly list item number 42
also. Yeah, same.
Weekly list item number 43.
The lease was cancelled. I am the purchaser from the original lease. But the matter may be remanded. One thing is, only our class, the miss case 8303 of 2015.
Lordship is remanding the matter.
The petitioner is a purchaser, bona fide purchaser, who's from a person from the lessee, original lessee, whose lease has been cancelled by the impugned order dated 18th May 1998 of the Tahsildar Bhubaneswar in W case number 349 of 85. Is this the resumption or is this what you're challenging?
Yes, ma'am.
Yes, ma'am.
All right. On the short ground that the petitioner had to be heard before such order was passed, it is hereby set aside and the matter is remanded to the Tahsildar Bhubaneswar. It will be listed there on 25th April 2022. The petitioner will on that day appear together with the downloaded copy of this order. Tahsildar Bhubaneswar is requested to complete the proceedings within 4 months thereafter. Till such time, the interim order passed with this court on 16th April 2012 will continue. Petition is disposed of in the above.
Weekly list item number 44.
None appears disposed.
I am for the OP number 5, Your Lordship.
All right.
Weekly list for orders item number 45.
None appears disposed.
Weekly list item number 46.
None appears disposed.
Weekly list item number 47.
No instructions, Your Lordship.
None appears.
47.
He says not. You say counsel petitioner states he has no instructions.
No, in item 47, opposite part number 1 has filed miscase number 6146 of 2009. That is a flag B. That is for grant of 1 month time to comply the order.
Who has filed this miscase?
Opposite party number 1.
But nobody's appearing. You are there.
Yes.
But this is a 2009 case, sir. Yes. Nothing survives. You say MC in the case number, nothing survives. Even in that earlier one,
in all these earlier ones, just put the miss case and say no, none appears. No? Only miss case in all these matters.
Still options. Weekly list item number 48.
That miscase filed by the state may be disposed of as infructuous because that period has
All right. That 6146, you say due to passage of time, the application has been entered infructuous, it is disposed of. Item 48, none appears. MC
My lord, I am appearing for item 48. I am appearing for the bank. Here I have filed this miscase for modification of the order of this Honorable Court 23 March 2012, wherein that order the Honorable Court has directed to the petitioner to arrange a purchaser for the stocks and pay the outstanding amount for the bank through LC. So bank will retain 15% of the LC amount and the 85% of the LC amount will be given to the purchaser. But the petitioner, since there was no time limit fixed on that order, the petitioner is taking the advantage of that thing. So he has not paid the amount since 19th October 2011. Still 12 crore is pending and he has stopped the payment, my lord.
What is the modification you want?
So we want the to fix a time limit for the said order.
At this stage, sir, you're coming, you never moved this application. It's all died a natural death now. 2009 matter, 2010 application. Till date, not heard in 12 years.
My lord,
what is the point in now fixing any date after 12 years?
We have given several memos, but it was not listed.
Please, I have been here in the Chief Justice since January 2010. I have not seen you mention this matter even once, sir.
Let's
see, the passage of time, the petition application has become infructuous. It's disposed of as such.
Weekly list item 49.
None appears dismissed.
I am for the opposite.
These are MC cases, huh?
I am for the opposite party also.
Right, sir.
Weekly list item number 50.
Item 50, my lord, I am for the opposite party.
All right. MC case, you say none appears.
My lord, I have instruction that the Lord Counsel for the petitioner, my lord, is unwell, my lord.
It's all right, sir. These are very old applications.
Yeah. Weekly list pastor matter item number 5.
May be permitted to submit on behalf of Mr. Senior Patnaik.
Sir, everybody's got their promotions, nothing is left, sir.
My lord, what I am submitting is that as per the National Industrial Tribunal, my lord, the date was 1/5/2018, my lord. From that date, my lord, the seniority has to be counted, my lord. My juniors, I was field assistant, my lord. Thereafter, I was regularized. I was appointed to that post. And from 1/5/2018, my lord, that post was there. So, my lord, from that period, I was to be made senior. Accordingly, I was, my seniority, in the seniority list, I should be placed above the juniors, my lord.
You've all crossed the age of superannuation, sir. Let's not go on with this. You say both petitioners as well as the contesting opposite parties have attained age of superannuation. They've both got their promotions. The issue only being of inter-se seniority, the court does not consider it appropriate to interfere in the matter, particularly since the petition has been pending for over 19 years. Consequently, the court petition is disposed of in the above terms. All these petitions.
My lord, only my
other three matters are offshoots of the original application.
Yeah. In view of the order passed today in 13183 of 2003, these petitions are disposed.
My lord, one more prayer can I make, my lord. If there is any retirement benefits that are being freezed or not giving to us, it may
that
be.
That is a separate cause of action. That's a separate.
And Malashmi kindly observe that the interim order is vacated. Because of that, we are not getting the pension benefits of the promotional post.
Supplementary list, fresh admission, item number 1.
May I please, Lordship? Lord, here, my lord, we are challenging Annexure 10, my lord. This is the order passed by the Learned CGIT, my lord, wherein the date of birth of the respondent worker was directed to be corrected and consequential benefits were directed to be given, my lord. I am for the management. Lordship, here the background of the case is that...
Sir? I don't think the other side has been served.
No, my lord, notice has not gone. This is the first time it has come.
So let's leave it all. Now.
My lord, my only predicament is, my lord, here the financial implication is around 11 lakhs. Both the respondents have retired in the meantime. In the year 2010, they have retired. What has happened, my lord? I'll just take 2 minutes, my lord. Here the scheme was framed in the year 1994, my lord.
So there's no stay of the impugn award.
No stay, my
They have
lord.
not gone for enforcement in the last 7 years.
My lord.
So
My lord,
what's
only one prayer I have got, my lord, because around 60 more employees of the same.
We'll leave the questions open.
Yeah,
We'll
leave
say-
the question, and lordship may only write that it may not be treated as a precedent because the
All right.
financial
While
implications are
clarifying
the
that the impugn order of the CGIT will not be considered to be a precedent, and that the questions of law arising therefrom are left open for decision in some appropriate case. The court declines to interfere.
only one observation, my lord, because here 70 other employees are there. It will open a floodgate for others, my
You
lord.
said
who-
it won't be treated as a precedent, sir.
My lord, that observation would.
It's already there.
Obvious, my lord.
The petition is disposed of.
Supplementary list item number 2.
None appears disposed from opposition.
Supplementary list item number 3.
None appears disposed from opposition.
Supplementary list item number 4.
The lordship, I beg pardon, my item is 3. Identical matter has been heard by this honorable court and adjourned to 2nd May.
What matter?
That is read WPC number 178480.
What is the matter about?
My senior, Mr. Anand Swai, will argue in this matter. my lord. He is out of station. For that reason, I am mentioning.
No, what is the matter about, sir? Sorry.
I don't have the brief. my lord.
Ah.
Identical matter, but identical matter has been heard by your lordship and adjourned to 2nd.
Supplementary list item number 5. Item number 5.
None appears disposed from opposition.
Page 12, representation is there. Challenging the inaction of.
Which item, sir?
5, item 5.
The petitioner's representation stated 12 June 2021 shall be examined by the collector Cuttack and after issuing notice to the petitioners and giving them a hearing. A reasoned order shall be passed thereon not later than 16th May 2022.
So Lordship's permission, may I be permitted to place the matter because Mr. Ponda is having some personal difficulties. My lord, in this case.
Which is this case number, madam? This is Daitari Durga.
Yes.
7771.
7771.
7771, correct.
My lord, here the petitioners are before your lordship. Being the ST candidate, they are entitled to get the post-matric scholarship. They are pursuing their education in yoga. MA.
Why is it matter before this court? Why is it? Before this court, this is a PR. Then why is it before this court on 11th April? 11th April.
Supplementary list item number 7.
May it please, sir. This matter, sir, challenges notices issued under section 153A of the Income Tax Act on the ground that the same is completely barred by limitation. Here, sir, if you may kindly have page 20, that is the impugn notice, sir. So you may kindly note the date, annexure 1.
The notice is not gone. So you say notice, Mr. Chimanka accepts notice.
Yes.
No coercive steps be taken till the next date. 8 weeks for reply rejoined up to the next date. List on 22nd August.
Please, grateful.
Both matters.
All matters.
All matters. Sorry.
Supplementary list item number 8.
Plus the date is
Extra copy में candidate.
22nd August.
Grateful.
मैंने extra copy में candidate.
Supplementary list for orders item number 8.
None appears.
I am for the respondent.
All right.
This matter was restored on 12/11/2021. But I think there is the cause list doesn't reflect the name of the appellants. Appellants lawyers, my lord.
Who are the appellant's lawyers?
My lord, Mr. Mahapatra, Dayananda Mahapatra, and even it doesn't reflect my name. I am appearing for the respondent.
All right. The names of Mr. Dayananda Mahapatra and Mr. Gauri Mohan Rath be indicated for the petitioner and respondent, opposite parties respectively. Respondent, appellant and respondent respectively in the cause list. List on 18th April.
Obliged, yours.
Supplementary list item number 9.
None appears to no opposition.
Supplementary list item number 10.
None appears to no opposition.
Supplementary list item number 11.
None appears to no opposition.
Supplementary list item number 12.
In item 12, my lordship, the virus of rule 4 of granting order 2004 is under challenge, my lordship. Similar matters have been posted to 28/2022, your lordship.
Give us the numbers list along with on 28 July 22.
My lordship, I'll give the numbers. And my lordship, I have a small prayer. In similar matters, my lordship, I already issued notice. I also serve a copy on the London AGA. Let them file the counter in this matter.
Item 12, I think, is school and mass.
I'll serve the copy, your lordship.
All right.
Obliged.
Supplementary list item.
I'll give a memo, your lordship, with a batch of cases. So I have to give a memo.
And a list may be given to me also.
All right.
That it will be easier for
Just take the numbers from
yes, your lordship.
Supplementary list item number 13.
None appears to no opposition.
Supplementary list item number 14.
14, my lord, infructuous, my lord.
Infructuous disposed of.
Supplementary list item number 15.
Item 15, my lord. Annexure 3, the representation is pending before the Tahsildar.
All right. The petitioner's representation, bracket annexure 3, be considered by the Tahsildar. Prior a call and after issuing notice to the petitioners and opposite party number 5 and giving them a hearing, a reasoned order shall be passed not later than 16th May and be made available to the parties not later than 23rd May. If agreed, it will be open to the parties to seek appropriate remedies. The court clarifies it has not issued any, not expressed any view on merits. The petition is disposed of.
Supplementary list item number 16. Item number 16.
None appears. This is no opposition.
Supplementary list item number 17.
None appears. This is no opposition.
Supplementary list for admission item number 18.
My lord, I'm filing the rejoinder affidavit to the counter of opposite partner 1. 18.
We'll set it down for hearing, sir.
It is for hearing, my lord.
All right, we'll just set it down for hearing. Rejoinder has been filed today.
Pardon, my lord.
We'll set it down for hearing, sir. We'll give it
Wednesday.
some other day. List on 14 July, sir.
14 July.
Supplementary list item number 19.
May I please?
They have to remain
The
present
challenge is-
telephonically. What happened?
My lord.
Transport council to remain.
Yes, he is here. My lord, Mr. Bhatt.
What are your instructions, sir?
That we have filed counter affidavit.
When?
Here, that counter affidavit filed.
We don't seem to have a counter.
There is no date.
When did you file, sir?
They are filed on September 2008.
Correct.
That is there on record. One Mr. Subrat Satpathy has filed.
All right.
The Lordship will see section 192 of the Motor Vehicles Act. It speaks about if your Lordship is holding this OLR publication.
That's right.
Yes, your Lordship will then find it at page 252.
Yes.
Using vehicle without registration.
Yes.
If a vehicle is a necessity of registration is required under the Motor Vehicles Act. Now, if it is without registration, they have a right to levy a penalty. Now, whoever drives a vehicle, motor vehicle, or causes or allows a motor vehicle to be used in contraventions of provisions of section 39 shall be punishable for the first offense with a fine which may extend up to 5,000 rupees. I'll just stop there. Now, the only invocation of this is this provision is in only respect of use of motorcycle without registration, motor vehicle. Now, the demand that is levy is made is respect of trade certificate. The concept of trade certificate is totally different. Now, your Lordship will kindly take up the motor vehicles, central motor vehicle rules. That is at page of that book. Start as 482 at 523, rule 41. Purposes for which your Lordship got that? Rule 41. Central Motor Vehicles Rules 1989.
Yes.
The purposes for which motor vehicle with trade certificate may be used. So if I'm a dealer, I need to have a trade certificate for restoring for the purpose of sale in my godown and showroom. Now, for that purpose, I need a trade certificate. Now, these are the conditions where I need a certificate for use. And this is only for the purpose of test drive. It is only for the purpose of storing the vehicle. So it's nothing to do with 192. 192 is for without registration. Registration happens only on sale. Unless there's a sale, 192 cannot be invoked. So what they have done, they have invoked 192 and levied a penalty and tax under the section 3 of the Orissa Motor Vehicles Taxation Act 1975. So that is clearly without jurisdiction.
Yes.
May Lordship, I will kind attention, Your Lordship's section 39. There is a clear provision for use of motor vehicle without registration. Section 39 prohibits use of no person shall drive any motor vehicle and no owner of a motor vehicle shall cause or permit the vehicle to be driven in any public place or in any other place unless the vehicle is registered in accordance with this chapter and the certificate of registration of the vehicle has not been suspended or cancelled and the vehicle carries a registration mark displayed in the prescribed manner. But there is complete prohibition of use of motor vehicle in any public place without registration. Provides provided that nothing in this section shall apply to a motor vehicle in possession of a dealer subject to such condition as may be prescribed by the central government. But a dealer is not required to register the vehicle. Subject to condition, he has to obtain a trade certificate. Well, Lordship, kindly see
Central Motor Vehicle Rules.
Central Motor Vehicle Rules.
521.
Rule 33. That is
Page
521. Man. The condition for exemption from registration. For the purpose of proviso to section 39, a motor vehicle in possession of a dealer or manufacturer or ancillaries shall be exempted from the necessity of registration subject to the exempted from keeping unregistered vehicle provided he has to obtain a trade certificate. That is subject to obtaining a trade certificate. Admittedly, here the petitioner is a dealer and annexure 3 is the trade certificate. So Lordship, kindly see annexure 3. Renewed from 26/5/2007 to 25/5/2008.
28/5.
After 28/5/2008, there is no valid trade certificate in favor of the petitioner. Next page, the go down has been inspected and the VCRs has been drawn up. The allegation is that has been pointed out. The allegation is the petitioner has violated section 192 of the Motor Vehicle Act since he has not failed to produce the trade certificate. It is a requirement under the law to possess the unregistered vehicle provided he has to obtain the trade certificate. He has not possessed the trade certificate and possessed 38 unregistered vehicle for sale. That is the violation. It is a condition precedent to obtain the trade certificate and possess the vehicle in the go down. Lordship, kindly see annexure 4. That is the vehicle checking report. His go down has been inspected and it is found in the last paragraph, the manager failed to produce the valid trade certificate. It is liable under section 192 of MB Act. Under section 3 of OMBT Act, the manager is directed to produce the stock receipts, sale figures, stock registers with the details of vehicle preceding 2 years before registering authority Ganjam on 6/8/2008. Admittedly, the petitioner has no valid trade certificate at the relevant time. So the 38 vehicles under the possession of the dealer is in clear violation of section 39 of the Motor Vehicles Act. It is mandatory requirement to the Orissa Motor Vehicle Taxation Act under section 5. There is provision for levy of tax. Let's kindly see on that book, page 879. Tax payable by manufacturers and dealers. But may I read, my lord, notwithstanding the provisions contained in section 3, 3A, 4, 4, B, C, and D, a tax at annual rate specified below shall be paid in advance by a manufacturer or dealer in motor vehicles in respect of vehicles in his possession in course of his business. As such, manufacturer or dealer under the authorization of trade certificate granted under the motor vehicle rules. Lord, in order to avoid to pay the tax, the petitioner has not obtained the trade certificate and keeping the unregistered vehicle with him. Lord, that is why he has avoided the tax. That is why search has been conducted under section 17(2)(17) of the Orissa Motor Vehicle Taxation Act. And the premises has been searched and it is found he has possessed 38 number of vehicles without any registration. Then
Yes, my lord. So far as section 5 is concerned, their allegation is not section 5 demand. It is section 3 demand. Their registration of the vehicle, so far as tax is concerned, so far as the valuation of it is concerned. Because the vehicle is registered as per the valuation, 5% or 10%. Now, section 3 relates to that. So what they are trying to tell me is that you have kept unregistered vehicle and you must pay me tax and as such penalty. It is not a question of section 5. Section 5 relates to a trade certificate, the tax, which is next page. If your lordship will see that how much I have to pay, the next page 680. That they have defined that what is the rate, annual rate. So if I have to keep 10 motor vehicles or 10 motorcycles, then accordingly it has been specified. 5,000 for one vehicle, thereafter additional. So that is not the demand here. Here is a case where I failed to renew my trade certificate.
So can you be better off than a person who has a registered vehicle? So it will be an advantage not having a registered vehicle then?
No. Question of registration doesn't arise. If I fail, the question is, if I fail to renew my trade certificate, then am I liable under section 39 to register?
No.
If he says no, then where is it? It is a question of renewal. Thereafter I have renewed. In August 2008, it has already been renewed.
Then what's that, right?
Question of harassment. Because now if I don't renew it, they come, instead of saying that you renew it, they gave me a demand under section 3. That is whole absurd. I don't have to register the vehicle, then sell it. Nobody will buy the vehicle then. It becomes a second-hand vehicle. They are like putting the cart before the horse. So that exemption have been granted of trade certificate is violated absolutely. I have been given admittedly trade certificate 3 years, difference of only 2 months delay. You told me that you give an application for renewal. Now kindly see the renewal clause. There is a renewal clause in the So question of rejection doesn't arise. Had there been a question of rejection, of my renewal, then the question would arise about the 39.
All right. Orders reserved.
Get
Supplementary list item number 20.
None appears dismissed. No.
Supplementary list item number 21.
Sir, 20. So in the meantime, there is no instructions
All right.
on behalf of Mr. Ekripal.
20, no instructions. All right.
Obliged.
Item 21.
This is relating to the EIL where we have filed a challenge the inaction of the opposite party for granting relief during the time of cyclone Fani. Filing.
Infrastructures. All right.
Due to passage of time, the petition has been rendered infructuous. It is disposed of as such. Sorry.
Supplementary list item 22. Item number 22.
None appears to since no solution.
Supplementary list item number 23.
May it please, sir. That there was a gentleman, Surendra Kumar. For the my lords may kindly see. He is my husband, my lords. Is at page 14, my lords. That indicates that all the family members have written that we are giving no objection in favor of Manin Mahanti. Manin Mahanti alias Gochait. Manin Mahanti, wife of late Pradeep Gochait. If she will get
Come to page 29 of the counter.
My lords, yes, if my lords direct me to see the counter, only I pray one paragraph of the counter, that is sufficient for my argument, my lords. Page 3 of the counter, my lords.
No. Come to page. That has not numbered. Come to page 8.
Page 8, my lords. I'm going to, my lords, page 8. Yes, my lord, page 8, my lords. Sir, read it the second para or first para, my lords?
Last paragraph, sir.
Last one. In the instant case, the petitioner has not made her application for appointment within 1 year from the death of the deceased government servant, Surendra Kumar Gochait, as stipulated in Rule 6 of Rule 9 of OCS Rules 1990. Rather, she has applied for an appointment under Rehabilitation Assistance Scheme on 29/11/14. That is after 2 years from the death of deceased government servant Surendra Kumar Gochait.
So what's your answer to this, sir?
My lords, here, my lords, my humble prayer before my lords. One who was working, doing the job, he expired. And in his place, his son applied for. He expired. Thereafter, my lords, my turn came. If my lords, that will be taken the plea, that rule does not permit, because you have not applied to, because after 2 years of his death, my lords, when my husband is there and his son is there, and he applied for, I cannot apply for him. This is a situation beyond control, my lords.
Sir, no. 2 years delay, where's the situation?
My lords, 2 years back, I did not know that my husband will die, and I should have applied for. My lords, may kindly consider. My lords, kindly consider. Yeah, widow. She became a widow at the age of 18 years.
So why are you shouting?
My lords.
Why are you shouting?
Sorry, my lords. Sorry, my lords.
The question is 2 years from the death of the deceased government servant.
Yes.
After death, within 2 years from the death, you should have applied.
My husband applied. My husband applied immediately after his death. And when he is going to about to get the job,
So when
he
did he
expired.
die, sir? When did he die? When did the husband die?
Minor?
When your husband died.
Yes, minor, I'm telling you. 14-10-14. 14-10-14 he expired.
All right.
But it is not a deliberate or a willful negligence or deliberate or a delay. Situation beyond control. After his death, 3 daughters and my daughters, they were all under overburdened my lords, and I have to take care of it. As my lord said, why I am shouting? By emotion I am shouting, but not so. But
Not for that,
properly.
sir. There is mic. We are able to hear that.
Yes, I'm sorry. I beg apology. Because we have not the habit of telling anything in the mic. Now we have got it. So
All
that
right.
is misuse.
All right, all right.
So, my lords.
No, let us hear him.
Yes.
Well, along with the application, the petitioner has not submitted any legal heir certificate that he is one of the legal heir of the deceased. And along with the application, she has not submitted her educational qualification document. And in the meantime, that 1990 rules has been superseded by 2020 rules, and the criteria of consideration is now totally different.
No, but this was a consideration already happened and it's challenged here, sir.
No, that consideration was done in respect of the husband of the petitioner. Petitioner's application has not been, because this is
No, but it's already filed, na?
Yes, he has filed. But rule, you're looking at 2020 rule.
But even under the new rules,
yes,
how it should be disqualified from being considered?
No, he has to be considered again under the new rules.
Whatever, you consider it again.
Yes.
You see, from the reply filed on behalf of the opposite parties to the present petition filed by the daughter-in-law of the government servant, for appointment into the rehabilitation assistance scheme, it appears that the plea taken about the application being delayed by 2 years is not correct. The husband of the present petitioner, who is the son of the government servant, himself died after making an application to the RAS on 14/10/2014.
Yes, sir.
Therefore, the application filed by the present petitioner within a month thereafter cannot be said to be time barred. Paragraph. Counsel of the petitioner then, the opposite party then states that the petitioner did not produce a legal heirship certificate and other relevant documents. He further states that meanwhile the scheme itself has been replaced by an RAS scheme of 2020. Paragraph. The court directs that the petitioner will make a detailed representation, public application, enclosing the heirship certificate to the opposite parties afresh on or before 2nd May 2022.
There is a format under the 2020 rules. There is a
under the 2020 rules as per the format devised thereunder.
Yes.
Full stop. If such application is made within the time stipulated, it will be heard, it will be considered afresh, and an appropriate order shall be passed thereon within 3 months thereafter. The decision shall be communicated to the petitioner not later than 8th August 2022.
2 months.
3 and 2 doesn't make a difference.
Minutes?
It will be decided within 3 months. Right.
I just submit my application within 2 months.
No, you submit it by 2nd May, sir.
Supplementary list item 24.
This matter has already rendered infructuous.
Infructuous is disposed of. All right.
My appearance may be recorded for the department.
All right, sir.
Supplementary list item 25.
Opposite party is Vigilance Department. So my appearance may be recorded.
All right, sir.
Yes.
But item 25, in fact, there are 2 prayers. So far as the first prayer that is challenging the annexure 8 is concerned, that has become infructuous. So far as the second part is concerned, my lord, your lordship may give liberty to the petitioner to approach the competent authority because they want that particular sand soil may not be put to auction because it is causing detriment to the interest of the local people. So far as the first pair is concerned, my lord, that was challenged query permit granting permission for a period
There are
of
two
7
prayers
days.
in the present petition. The first prayer is rendered infructuous. As far as the second prayer is on account of passage of time. First of all, as regards the second prayer, the representation, where is your representation? Made by the petitioners annexure.
That is annexure 9 series, my lord. 9, annexure 9. My.
Annexure 9 series shall be considered afresh by the opposite party number.
By the opposite party number 2, your lord.
2, that is Collector Baleshwar.
Yes.
And after hearing the petitioner as well as, and issuing notice and hearing the petitioner as well as opposite party number 5. No, now it's not necessary. 5 is not necessary.
Not 5.
This representation is dated 2015, my lord.
I know he's talking the future. An appropriate order should be passed in respect of the second prayer, the petition. Not later than June 2022. The petition is disposed of the above.
Supplementary list item 26.
Lordship, I am for the petitioner, my lord. Today in the courtroom, I have received the counter filed by the opposite party number 3 to 6.
All right. Reply of opposite parties 3 to 6 is on
I have
record.
already shot the counter in the court on 36 2017. But the note
Anyway, we're not going to it. Rejoinder will be filed before the next date.
Another prayer, my lord. Kindly have a glance to the order number 2. The government has directed to produce the investigation report, my lord, by the RDC Sambalpur. That is order dated the 1st December 2016. It is regarding transfusion of the HIV positive blood to a normal patient, my lord. There was an inquiry by the RDC Sambalpur. That report was called for, my lord. I will produce on the next date. I will produce.
The report of the RDC Sambalpur also be requisition for the next date. Mr. Mudali states that he will produce it on the next date. This on 21st July.
Supplementary list item 27.
I'm for the opposite party 13. It's a PIL. 27 PL.
Respected judges, we have no instructions.
27, no instructions disposed of.
Supplementary list item number 28.
May I please, Lordship? Lordship, the petitioners has filed this PL Lordship seeking widening of the road in the Commission town area.
In
Here,
this
Lordship,
matter,
the
pursuant
opposite
to my
party has
lord's
filed
direction, I have filed
the counter, Lordship.
affidavit in the month of September 2021. In the meantime, more than 7 months have elapsed. I will obtain instruction regarding the present status of the land acquisition.
What is the present status?
This is regarding construction of 2 laning to 4 laning, because there are some private lands were there that was required to be acquired under the provisions of Land Acquisition Act. So that we have stated in the counter affidavit. In the meantime, 6 months have elapsed. I will obtain the present status.
Or Mr. Mudali seeks time to obtain the instructions as to the present status. It is requested on 19 July.
Supplementary list for admission item 29.
Please, my lords. Item 29, my lords, this is an ITA. Lords, need some preparation. Your lordship may have it next week if,
all right.
If your lordship
At the
so
request
please.
of counsel for the appellant list on 27th April.
27th. Great.
Supplementary list item number 30.
Lord, 30 here, Lord, a similar matter is there. I have to check whether that case, whether the Honorable Court has admitted on this issue or not.
All right. At the request of Mr. Satpathy, learned students and a counsel to the department list on the same date. When did you say? 27th April.
Supplementary list item number 31.
31, and Lordship, see, here is a case that a tribunal has reduced the percentage of the
profit.
And no, Lord, we are here. The point is the tribunal head, your Lordship, see, running page 21 for a moment.
what is the point? We also find the assessor has not doubted the genuineness of the expenditure under both the head of expenditure, but restricted the want of original bills and voucher. Now you will also see the order of the assessing authority. Running page 25. Fifth line.
31.
25, running page 25 of the appeal memo. For fifth line, to verify the genuineness of expenses, the AR was asked to produce the original bill, voucher, and labor payment register documented evidence. In reply, AR could not furnish the complete bill and voucher as per the above expenses. If it is there, how could he know that the RCM has not doubted the expenses and he has produced everything? He has not produced it. It is admitted fact. Tribunal error in finding that the assessing authority has not doubted the issue.
This is a notice returnable. 28th July.
Supplemental list item number 32.
Well, similar was in past in ITA number 86 of 2018. Same.
All right.
Sorry, Lordship, see, here is not the deleting the addition made under section 68.
What's this defect 5A?
Let us remove it.
So defect copies.
Is not defect. Copy into annexure 1. Annexure 1 is not original copy. True copy is
attested copy.
Attested copy have been filed. If you also ignore it, or I'll file it.
Cuttack District Tennis Association.
Tennis?
No, this is the Gangol Wincom.
Yes, yes.
What's the question now?
Question addition deleted under section 68 of the Income Tax Act on the ground that I have come across one judgment of the Calcutta High Court, identical matter. We'll also see the judgment here. The Calcutta High Court not held.
All right, notice returnable, same date. What is that date? No. Notice returnable.
Supplemental item 35.
Well, 35 case is admitted in Orissa Cricket Association ITA 56 of 2018 and date has been fixed on 2nd August 2022. 56 of 2018 and 55 of 2018. Odisha Cricket Association.
All right, list along with. So just give us the details on the same date, 26th August.
Yes, 2nd August.
2nd August 2022. List along with.
36.
36. Well, there are 10 appeals. ITA 83 of 2012, 84. I given the list. Maybe fixed at a time. 10 appeals are there.
No, this goes with which one, sir? 35 or 36?
Yeah, 36, I say.
36. Okay. List along with all these appeals on 10th August.
Supplemental list item 37.
37. Here is a case not.
That IA is allowed. Huh?
It has been allowed and the question is not framed. Area salary. Whether running page 8 of the appeal memo, whether on the fact and circumstances.
I think we have decided the similar thing. This is the partner's salary.
No. Here is a case not corporation, state corporation. He has provision for area salary. It has been cleared under 37. So AG has been, you'll also see the page tribunal order.
Page 10. So they're following an earlier order, sir.
But
What happened to the earlier orders? You don't know.
earlier order, I don't have that earlier
Alright.
order.
The question of law sought to be urged by the revenue in the present appeal reads as under. Take from page 8, 6A. And in pursuit of the impute order of the ITAT reveals that the ITAT has followed its own orders for earlier assessment years involving the same assessment. On the ground of consistency, the court declines to frame the question as urged. The appeal is dismissed.
I get salary. It's pretty good.
Supplementary list item 38.
Item 38 and 39, the applicant in the meantime availed under Vivad Se Vishwas scheme. So maybe permitted to withdraw, not press.
All right.
And there is one more ITA not listed today, 175 of 2018.
We'll take it on board.
Same.
Yeah, take that 175 on 2004 on 2018 on board. Counsel, the appellant does not press these appeals as the appellant has opted for the Vivad Se Vishwas scheme. The appeals are disposed of as not pressed.
And 175 is not listed. He's saying that it should be disposed.
Yeah, taking on board and
Supplementary for hearing item 40.
May I please your lordship? 40 is matter related to Sishu Bhavan, and a lordship directed to constitute a committee and directed to visit the Sishu Bhavan. And accordingly, we visited the Sishu Bhavan. I placed the videograph, photographs, and committee's report before a lordship. And a lordship directed the superintendent Sishu Bhavan to file an affidavit. To that effect, they filed an affidavit on 49/2000. They filed an affidavit.
Today they're handing over one more thing, sir.
Yes, we have filed through e-filing and giving the hard copies. I'm also serving copies to my friends, my lords.
All right, you examine it, sir.
Yes, you are also directed to give the photographs also. We have also annexed the photographs.
All right.
The subsequent affidavit copy not served, my lord.
No, they're just serving it
We are
today,
filing
sir.
today in court. We have given to your friends. We'll give it to
My lord.
Opposite party number 3, namely the superintendent of the Sishu Bhavan, has filed an affidavit today in court, copies of which have been handed over to counsel for the petitioners. Certain photographs have been enclosed with the affidavit, making it appear that the Sishu Bhavan is now much cleaner than before. It will be open to the same committee of 3 advocates to visit Sishu Bhavan again in the next 10 days to verify if the facts stated in the affidavit are correct. List on so 25th April.
My lord, last occasion also, you also directed to list it for orders, my lord.
Sorry.
Now it comes funny. Last occasion, lordship directed to list it for orders, but again it will come on after hearing, my lord.
Okay, listed for orders.
Visit on 10 days. Yes, you will also say directed to your matter to be listed 25th. Better will also fix a date of their visit so that will also.
Why? Let them visit any time. Let them
My
visit on any day, sir. That's the whole idea.
much obliged, my lord. Much obliged.
Let it be on May or April last.
All right, list on 18th May. Yes, 18th.
I think it's a vacation, my lord.
No, 18th is before
Last
vacation.
working day. It's the last working day.
No, 20th is last working.
Oh, sorry, normally it's.
Right. 18th May.
18 May, my lord. Much obliged.